This conference will now be recorded.
Oh, I give up.
Connor, I think we're probably ready to begin.
Oh, well, thank you very much. I'm going to just turn it over to Matt and Reeve to kind of just provide some framing remarks. And then I think after that, Todd, you can take the role, and then I'll give a few introductory remarks and we can get into it.
Thank you, Connor. Appreciate it. Very briefly, Connor had asked me to address a comment that Stephanie Tatham had made in advance of the meeting, and I want to let Reeve address the particulars. It does raise some. Stephanie, let me just ask you: should we circulate that comment to the committee?
No, but I'm happy to sort of share the concern that I raised, which is just that I'm
well.
Very
hold on. Let me turn it. Let's wait till Connor recognizes you.
Okay.
Steph had raised some concerns about whether the draft that was prepared by staff was faithful to the committee discussion last week or the last meeting, and also had raised some process concerns and in particular requests for additional committee meetings, I think beyond that which have been scheduled for this project. Before turning it back over to Connor, and maybe he wants to hear from Steph at the outset here, or it's his meeting to run, I thought it would be useful for Reeve to speak to the issue, to speak to the staff draft that was prepared since the last meeting and the reasoning behind it, and what the staff was trying to accomplish by way of facilitating the committee's work. So with that, let me turn it over to Reeve.
Great. So thanks, Matt and Connor. So yeah, I just want to ever so briefly, just for sort of the committee's benefit, sort of lay out what we had hoped to accomplish with the staff draft that you have in front of you. We acknowledge it's certainly true that it could definitely be improved, in various respects. And indeed, you'll see in the draft itself there are a couple of points where we sort of laid out some different options that the committee might consider. So I wanted to sort of briefly go through what we did, which I think we think faithfully captures, the committee's intent from the last time, and then also specifically what sort of those discussion points are, where there was some some different views, or some thoughts as to sort of the best way to accommodate this and sort of highlight what we had hoped to achieve with that. In a way that will hopefully be useful to the committee as they're walking through the preamble and then the recommendations to sort of consider what the different decision points might be. So sort of first, the overarching principle that sort of animates the entire draft is we do think that there's some value in defining rules on rulemakings as a category of things that are legislative rules, and therefore would be enforceable by a private litigant on judicial review. Now, of course, we acknowledge that, or certainly the intent is not to say that every agency should have such a thing. We're simply identifying this as something that, many agencies do have and that they found valuable for reasons of accountability or transparency. But the goal is certainly not to prescribe that this is necessary in every single case, but rather to lay out some of the benefits that could be associated with having such a rule in those particular cases where it might actually make a lot of sense. And then, of course, the intent is not to prescribe what the contents of such a rule should be. If an agency doesn't indeed decide to adopt a rule on rulemaking, as we've explicitly tried to achieve in the draft itself, we just laid out a pretty extensive menu of options of things agencies could consider, including in a rule on rulemaking. But the intent is certainly not to say that it should have X, Y, and Z, rather that you should just, consider the possibility of including some of those things. We also are very, I think, explicit in terms of encouraging agencies and promoting the idea of, what we call explainer documents, at least in one version of the draft. Now, query whether that's the best term to use, and we're certainly, interested in discussing, whether there's maybe a better term, a more descriptive term. But the goal is to really encourage agencies that, outside of rules on rulemaking, there are definitely value in having things on their website, guidance documents, other things available that explain how the rulemaking process works, and provide greater transparency to the process. There was definitely a lot of interest, I think, on the part of the committee in the last meeting on, promoting the idea of those sorts of explainer documents. And our goal in this draft is really to highlight that. To explain what these things are and to encourage agencies to consider using those in addition to any rule on rulemaking they might adopt. One additional thing, and this is where we sort of framed the draft a little sort of in the alternative, is Jillian Metzger, Peter Strauss, and others made the very important and I think good comment the last time, that there's also the possibility that the agency might want to issue something that would essentially be a policy statement, and therefore would be binding at least on lower level agency staff, but would not be enforceable in a court. It's not something that a private litigant could use on judicial review and require the agency to adhere to. So we tried in both, in the version of the recommendation you see, to accommodate that. And we sort of come up with sort of two alternative ways of achieving that. One is the actual language that you see, where we basically distinguish between rules on rulemaking and explainers on the other hand, and define explainer a particular way. An alternative approach might be, and we've offered this, I think it's in the third comment, the comment on the second page of the draft that Todd circulated. It might be more fruitful or more productive rather than defining this term explainer, which may not necessarily be widely used or may be not the most useful term, to instead distinguish between rules on rulemaking on the one hand and then guidance documents on the other hand. We sort of laid out three different types of guidance documents. One would be the type I just described, where the agency intends it to be binding internally. And for those types of guidance documents, I think there's definitely value in making those available so members of the public can access them. There may also be guidance documents that the agency intends to be binding internally, but there's really no value in making them public. So, there may be just purely procedural matters, what sort of font you should use for the NPRM and that sort of thing. There's no interest to the public. So we distinguish that second type of guidance document. And then finally, there might be guidance documents that the agency doesn't intend to be internally binding either. They're just purely in the nature of FAQs or background descriptions and so forth. And so sort of breaking out those three different types of guidance documents, I think, is useful in terms of providing context to agencies of what we're talking about. But it also maybe further emphasizes this idea that it's perfectly legitimate for the agency to use a guidance document to announce certain policies that are binding internally but not externally enforceable, and to make those sorts of things publicly available. The last thing I'd note on that point is, we tried to accomplish that in the alternative framing. Depending on which way we go, there definitely will need to be some cleanup language, both of the preamble and of the recommendations themselves. We hope that'll be a topic of discussion for the committee. And one of the things that I think we'll want to do regardless, and that I think will be valuable, is refer more explicitly to our prior recommendations on guidance documents, interpretive rules and policy statements, and specifically accommodate it within that framework. which I think, basically we can do, in the context of the preamble. The key upshot of those recommendations is that if an agency does issue a guidance document that's binding internally but not externally enforceable, that there should be an opportunity for someone to argue to higher level officials within the agency that there should be an alternative approach taken. So, we'll want to make that explicit, but I think we can pretty easily accommodate the goals of those recommendations within this recommendation.
Are you done, Reeve?
I am. Yeah.
Is Peter Strauss on the phone? Is Peter Strauss joining us? The reason I ask is much of what you said, especially about guidance documents being binding in the sense that they're binding on at least lower level staff, resonates with and I think reflects Peter's comments at the outset of the last meeting, and so that's the reason I'm asking if Peter's on the line. But I think we have in any event, even if he's not, I think we have a pretty good understanding as to what Peter's views are, and I suspect Jillian Metzger's too. And Peter, of course, had participated in the roundtable extensively, about which Todd spoke at the last meeting. So with that, unless Reeve has anything further, I'll turn it over to Connor, or turn it back to Connor.
Oh, thank you very much, Matt and Reed. That's helpful background on the drafting, and thanks to everybody at ACUS for the hard work in putting this together on short notice. Before we go further, I want to turn it over to Todd to call the roll.
Thank you, Connor. So I'm first going to call the names of committee members. We have Connor Rosso, who's the chair, Paige Bullard, Clay Cook, Christopher DeMuth, Jonathan Doles. If you could just please say here if I call your name. Michael Fitzpatrick. Ooh. Nathan Kazmarek. Elliot Laws.
Here.
Erica Leighton, or Leighton rather.
It's Litson.
Oh,
Rhymes
Leighton. Okay, there you go. Neither. Okay. Michael Livermore.
Yep, I'm here.
Okay. Charlie Maresca. Danny Fischler, who's an alternate for Christina McDonald.
I'm here.
Danny, are you here? Yep, great. Ricky Rivez. All right, we are having a problem now with mics picking up sound. So if you're not speaking, if you could please just mute yourself after I call your name, that would be great. Thank you. Sheila Novak is an alternate for Carrie Ritchie. Jonathan Rose. Jay Schwartz. Sid Shapiro.
I'm here.
Ganesh Sitaraman.
Here.
Peter Strauss. Jonathan Weiner.
There. This is Jonathan Weiner.
Kin Yu. Marion Zobler.
I'm here.
Great. So those are all the committee members that have RSVP'd. So if you could please, if I just called your name, if you could please enable your webcam, that would be great. Now I'm going to call the names of people who are not on the Committee on Regulation, who have RSVP'd. So Andrew Emery.
Here.
Jeff Lubbers.
Here.
Dan Cohen.
Here.
Robert Stone.
Here.
Kate Sargent.
Here.
Jillian Metzger. Steph Tatham.
I'm here. Thanks.
Brady Tonsing.
Here.
Great. Kenny Wright. Levon Schlichter.
Here.
Ryland Lee.
Here.
Jim Tozy.
Here.
Paul Noe.
Here.
Rob Carter. Tim Mullins.
Here. Also, I'll be Jonathan Doles' alternate for DOT until he arrives at 3:30.
Okay, great. Then we have Maureen Ruskin. Lisa Stewart. Peter Robbins.
I'm here.
James Goodwin. Neil Eisner. Bridget Dooling. Radha Vishnu Vajala.
Here.
Keith Holman.
I'm here.
Jennifer Levin. William Funk.
Here.
Daniel Flores. Okay, those were all the people who I heard from as RSVPs. Is there anyone whose name I have not called?
Yes, this is Don Elliott. I thought I was a member of the committee, and I also thought I had responded, but one way or another, I'm here.
Okay, all right, great.
Hello, this is Stefan Babbage from SOL. I did not respond, but I believe that Radha responded in my behalf earlier this morning. I just learned about this meeting.
Oh, okay, I'm sorry. And can you just say your name again?
Stefan Babbage.
Oh, okay, sure. Yep.
Thanks.
Is Don Elliott, Todd, Don is a member of the committee?
Well, I believe so. He's not, unfortunately, he's not on the RSVP list that I had saved in the
Judicial review. Don is judicial review.
Okay, so I used to be a member of the committee, and I'm now on judicial review, so I'm not a member of the committee. So that's fine.
Well, we didn't move you. You would have moved yourself, Don.
Well, it's complicated. We don't need to go into it. We discussed it, but I never got any notice that it actually happened. So
okay. Well, I just want to, but Todd, Connor has a list or knows in his head who's a committee member and who's not, because while obviously all ACUS members have speaking privileges and their views are very much welcome, only committee members can vote. And that's an important thing, obviously, to keep in mind.
Yep, I think Connor does, and he's also going to go over the rules that will describe that. So Connor, I guess I'll just hand it over to you.
Okay, thank you, Todd. Yeah, so basically the same rules as last time. As we just discussed, ACUS members have full speaking privileges and can unmute themselves. But as Todd just said, please keep your microphone on mute. And two options to get recognized for speaking. One is raise your hand. We do have a number of people here, so the boxes can be a little bit small, so you can also add a comment in the chat feature if you want to be recognized. I think that worked pretty well last time. And then remute yourself when you're done. We welcome participation of non-ACUS members, but we do give priority to the ACUS members. If you're not an ACUS member, please use the chat function to indicate that you'd like to speak. We'll turn to you, and the person running the software, the GoToMeeting software, will unmute you, and then when you're done speaking, remute you. Please, this is hard to do, but please use the chat function only to speak or to vote, not for substantive sidebars, only because when we have two parallel conversations, it can get unwieldy and kind of get off track. As Todd and Matt just said, only the members of the Regulation Committee or their alternates have a vote, and so please do not vote We'll probably vote by hand, but if we do vote in the chat function, either way, please don't vote unless you're a member of the committee. And if we do votes today, I'll go over the procedure for that quickly before we take the first vote. So with that, sometimes when we do these discussions, we start with the draft of the recommendation itself and not the preamble. Yes, I'm sorry.
I'm sorry.
Yes,
I'm sorry
please.
to interrupt you. Just one more logistical matter. Daniel Flores just emailed me to confirm that he is in fact on the line. I don't know if there are any technological problems, but he is on the line.
Okay. I do see somebody who does not have a name, so 2 people, so maybe one of those is Dan and somebody else, if they could announce themselves. Okay, well, feel free to use the chat function as well and write to me or to everybody. I do see 2 people who have, I think, called in but don't have a name on. Any other preliminaries before I dive in? So sometimes when we do these meetings, we start with the recommendation, but I think today it makes more sense to start with the preamble because the preamble includes some kind of threshold issues. And so I think it makes sense to open up a discussion on the issues that Matt and Reeve had mentioned with respect to the categories. I think one issue I want to draw your attention to is the text in the second paragraph as well as footnote 1. And I think it's important that we agree on a definition of legislative rules. Otherwise, I think there's a potential to just go in circles. And I want to emphasize, you don't have to think this is the right definition, and the case law uses this different ways, but we're defining legislative rules consistent with prior ACUS recommendations to include both substantive and procedural rules. And the idea is that they are internally binding on agency staff and also externally enforceable. So that's in the second paragraph. So that's the definition that we're using for legislative rules within this recommendation. Now, how we bucket everything out with respect to rules on rulemaking or explainers or guidance, I think is what we should discuss first. But I think it's important we all agree on a definition of legislative rules. So with that, I'll open it up to discussion on the sort of threshold issues that we heard from the ACUS folks from at the beginning. Danny Fischler.
Hi, thanks, Connor. And thanks for the explanation at the beginning. I found that helpful. I had a similar reaction to what I suspect is Steph Tapham's concern, which was that my impression from the discussion that we had last time was that we were going to be much more agnostic as to the form and enforceability of these rules. We could potentially describe some of the options, but I found the dichotomy that's introduced here between legislative rules on the one hand and explainers on the other hand to be troubling, in part because I think it should be possible for agencies to put things in the CFR that they don't want to be judicially enforceable, and to just make that clear, because the CFR is a great place to put things that the agency wants to codify and bind itself to and make the public aware of. So that was a concern that I had, where the definition of legislative rules that's included here focuses very heavily on judicial enforceability. And I found that personally to be unhelpful in terms of what I was hoping to use this recommendation for and encouraging folks at my agency to regularize. So, thank you.
Tim Mullins.
Yeah, hi, this is Tim Mullins with DOT. I just wanted to add to what Steph and Danny just made. I think, obviously our rule on rules was something that ACUS looked hard at and talked to us several times, and we also obviously kicked off the last meeting with a presentation on it. But our rule on rules explicitly does not make the portions of the administrative rule enforceable judicially, and that was done intentionally. And it was because what Danny said. I mean, we want to have
clarity to the public and transparency and letting people know what our processes are, but we don't want to do that in a way that, you know, just trips ourselves into administrative risk, or it's just it's a way for us to tell people how we're going to do things. But I mean, I think if ACUS wants to push for judicially enforceable rule on rules, I think it's going to lead agencies to not do that and to take them into not out of the CFR, because why would you make that? Why would you do that yourself? The point is to be clear about what your processes are, and also putting them in the rules does, I think, make agencies take them quite seriously. And we don't like to disregard our processes, but you know, we considered this issue significantly internally and came down with the idea that it's worth for the public to have it in CFR, but it was not something that we wanted to make enforceable, and therefore we were explicit in our rule that it was not subject to judicial review for all aspects of it. So thanks.
Steph, a couple folks have mentioned you, so you can summarize your comment or respond to points made, and then we'll go to Ryland.
Sure. Thank you very much. Yeah, I agree. First of all, thanks for a great recommendation. I do think this is a really terrific starting point, and there are a lot of really helpful suggestions in here, especially about why agencies might want rules on rulemakings and the different policy reasons that support them. I did have concerns with the discussion of judicial enforceability, and I wanted to point out that in our discussion on interpretive rules and on guidance documents, we explicitly didn't take on the question of whether those types of materials would be judicially reviewable, because, and I think part of our reasoning in the Committee on Judicial Review is like courts will decide that for themselves, regardless of whether or not agencies tell them that they are not judicially reviewable. Agencies are able to describe their intent, but I am a little worried, you know, as others have shared, about the practical effect of a recommendation if it continues to say that legislative rules are judicially enforceable, would be to discourage agencies from adopting those types of rules for fear of litigation. And you know, I think the DOT example shows that there are benefits to putting these in the Federal Register in terms of transparency, but the DOT regulations do have a disclaimer saying that it's not intended to be judicially reviewable. So I guess I'm just trying to figure out, you know, if we want to say anything on judicial reviewability or leave that to the courts as we've done in prior recommendations. And if so, what it is that we ought to say. Is it that we're cautioning agencies that if they put it in the Federal Register, you know, courts may decide to review it or treat it as creating a private right of action? Do we want them to be clear about whether or not they intend for it to be judicially reviewable? And so I think taking a step back and trying to figure out what it is that we want to say about judicial reviewability without assuming that just because it's a rule that's in the CFR that it is judicially reviewable would be helpful.
Ryland.
Hi, thank you for the opportunity to review the draft recommendations. I have two comments about the preamble language. And the first one is to just echo what my colleagues have said. I also think, you know, having rules be judicially enforceable definitely creates worries in terms of additional litigation. And I'd also note that under the policy consideration section, where we talk about the benefits of rules on rulemakings, efficiency, predictability, accountability, and transparency, I mentioned this last time as well, but I think many of those benefits can be obtained even if the rule is not judicially enforceable, or at least obtained in large measure. And I think of, you know, existing guidance on rulemakings that are not judicially enforceable, like BO 12866 or OMB Circular A4, which I think do provide a lot of, you know, these benefits even though they are not judicially enforceable. My second comment goes to the distinction drawn in the preamble between explainers and documents that are not legislative rules but set forth binding rulemaking practices. So basically between the third and the fourth paragraph in the preamble, I was just a little bit confused as to what is the difference between what's mentioned in the last paragraph of the preamble and explainers, and I'd appreciate some additional clarity in that. So maybe we can discuss that as well.
Todd, do you want to speak to that quickly, or do you want me to go to Jeff Lubbers?
I mean, I can speak to that. So explainers, what we mean by explainers are documents that explain the rulemaking process, but that are not binding. They're not. I guess what we said about explainers is that they're not judicially enforceable. They're more or less just descriptions of how the agency carries out its rulemaking process. And then we draw a distinction between that and legislative rules, which is currently worded are documents that are judicially enforceable. Of course, the committee can decide whether that language stays in or not, but as it's currently drafted, that was the distinction that we were trying to draw.
Okay, Jeff Lubbers is in the queue.
Could I follow up briefly on that?
Of course, yeah, sure. Then we'll go to Jeff.
Sorry, I guess I'm just still a little bit confused, because in the last paragraph of the preamble, it says agencies can issue these documents that are not rules, but that bind lower level officials. And then the text says, if these documents are publicly available, they may qualify as explainers. So it kind of sounds like, these binding documents can also be explainers if they're made publicly available. Is that the case?
I think that's how it is worded, and of course the committee can decide on alternative wording. But if an agency, I think what this is saying is that if the agency decides to make such documents publicly available, they could qualify as explainers. They wouldn't necessarily, but it's possible. We didn't want to exclude the possibility that some of those documents could be explainers.
Which in comment TR3 would be sort of like sub-bullet A would be in the current main draft encompasses and explainers. Jeff Lubbers.
Thank you, Connor. So I think the main goal of this recommendation is to get agencies to provide more information to the public on their rulemaking processes. And I agree with the previous commenters that there are some things in the preamble that might deter them from doing that by focusing on the judicial reviewability of them. And it's also confusing on line 23 when we talk about documents often combine external facing provisions which purport to bind the public. Well, we're not really talking about binding the public with respect to these kinds of rules at all, I wouldn't think. So I guess and it's also troubling to me that the title of the recommendation is rules on rulemaking, which we then define to be legislative rules, which are judicially reviewable. So I think a better title might be something like agency information and guidance on their rulemaking processes. And then we could kind of focus on explainers and guidance and all the things that we want agencies to do. And then sort of as a side matter, we could maybe acknowledge that an agency might want to make rules on rulemaking that are certainly binding on their staff and possibly even legislatively reviewable. But I think we've sort of taken our eye off the ball a little bit.
Follow-ups on Jeff, and then I have folks in the queue, but any direct responses to Jeff Lubbers?
I think it would be, Connor, this is Matt. I think it would be useful to hear further from DOT on whether any portion of its rule or rules, whether DOT considers it binding, what its intention was there, whether binding means binding in the sense of being a legislative rule with the force of law, or binding in the sense that a policy statement might be on internal staff. Because what we heard from DOT, and maybe Todd can jump in here too, sounds a little inconsistent with statements that I've heard from DOT, I think, including the general counsel there, about what the intention of DOT's rule on rulemaking is. Todd, do you have any further thoughts on that subject before maybe we hear further from DOT? Because I think we should clarify, this is a very important point I think we should clarify, and if the committee doesn't think that if there really are no rules on rulemaking in the sense that the draft recommendation defines it, and no agencies really have gone down that path, then the recommendation probably should be reoriented.
Well, Matt, let me just say something. DOE comment does indicate that their rule on rulemaking is binding on the agency at least. So
do they mean binding in the sense of binding as a legislative rule would be, or do they mean binding in the Peter Strauss sense that and the policy statement sense that yes, it's binding on staff, but the agency in effect reserves the right at higher levels at least to revisit as it deems fit without having to promulgate a whole new rule and so forth?
I think they mean the Peter Strauss version, but the actual rule provision in the DOE example is just a one-liner.
Bill Funk, I see you shaking your head.
Yeah, I just read the DOE final rule on the subject that Dan Cohen gave us the cite to, and they say it's binding on the agency. And they go through a long description, pages in the Federal Register describing the arguments pro and con from their perspective. I mean, having been the previous Dan Cohen many years ago, I'm surprised that they're taking this position, but it was really quite clear that they meant this was to bind the agency in the sense of judicially enforceable, not in the sense of just binding lower level people. They don't want to be able to make exceptions.
I think that's interesting. Thank you. Is Dan on the line? I don't believe so.
I am actually. So I'm listening to what everybody thought we said. So that's great. It's an interesting debate.
Do you want to add anything?
Yes. I mean, it is true. We went back and forth on this notion of, is it a legislative rule, a guidance document? The prior version of this rule, this rule was actually originally promulgated maybe just after Bill left. I can't recall exactly, actually. It was in the mid-90s. Was treated as a guidance, but it certainly ended up in litigation in a number of instances. It became a question when we didn't follow the rule before we did this change. So it wasn't like saying it was guidance stopped that litigation. It stopped the judicial review aspect. So we just took it as a more pragmatic thing that when you read what we said there, the point we were trying to make was where we got in trouble is where we didn't follow our own rules. And so if we thought it was important enough to write it down, then we should probably follow it. Obviously, if a court or a statute told us to do something different, we would do what the court or the statute told us to do. But we don't intend to do anything different than what we said here. So why wouldn't it be binding on us? And if someone then wants to sue us for saying we're doing what we said we were going to do, that seems a hard argument to make.
Thank you, Dan. I want to just take up Matt's call to hear from DOT briefly, and then we have a long queue, which I'll get back to. But DOT, did you have any further thoughts?
Sure. This is Tim again. So I put in the chat, and I know I'm breaking the rules about what should be in the chat, but actually our provision on it. And so, I mean, it's pretty clear. I can just read it out loud, right? Which is say this subpart is intended to improve the internal management of the department. It is not intended to and does not create any right or benefit, substantive or procedural, enforceable at law or in equity by any party against the United States, its agencies or other entities, etc. In addition, this subpart shall not be construed to create any right to judicial review involving the compliance or non-compliance with this subpart by the department, its operating administrations or offices of secretary components, its officers or employees or any other person. So I think that's pretty clear. I mean, I think our view was that this was a procedural rule that didn't create substantive rights toward third parties. So it was binding on the agency in the way that many other actions that don't have to be rulemakings are binding on the agencies, but that it didn't create any other rights. And therefore, this disclaimer, I guess, is pretty explicit. I think if other comments were made by general counsel or other leadership, I think it was about, I just want to stress, I mean, we didn't have to do this rule, right? We did it because we felt it was important for us to be clear about what our processes were. But in our view, this was an internal procedural matter, therefore not something that would be judicially enforceable.
I mean, Reeve, I don't know if you have any thoughts on it. That's very helpful. I do think we should just stipulate to some terminology here. The fact that something is procedural does not mean that it, as ACUS has used the term, and others like Ron Levin has used the term, does not mean that it's not a legislative rule. You can have a procedural rule that's legislative in character. So I'm just, the terminology here is, I don't know, the terminology here is tripping us up to some extent.
I guess there's a narrow view of legislative rule, which is that anything in the CFR is legislative, but our view maybe was more about the substantive versus procedural side rather than legislative versus non-legislative
just from
side.
ACUS's perspective, I mean, I know there's DC Circuit case law on this question of if something appears in the CFR, is it necessarily a legislative rule? I think that probably the answer is no. I just want to be very clear that ACUS has used the term legislative rule to encompass in prior recommendations, and I think one of them is cited in the draft recommendation here, but ACUS this came up at a plenary session. ACUS specifically used the term legislative to rule to encompass both procedural rules and substantive rules. Now that doesn't answer the question where the committee should go here, but we probably should stipulate to some terminology to avoid a confusion here.
Yeah, I try to emphasize that we have this internal definition that's consistent with ACUS prior recommendations. And I think the judicial review question is distinct, what we want to say about judicial review. But Paul Noe has been in the queue for a long time. I want to recognize Paul.
Thank you, Connor. Can you hear me okay?
Yeah.
Okay, I'll be the heavy from the OMB guy in my personal capacity here, and just respectfully disagree with some of the statements, including DOT, that you should take off the table the idea of agencies or an administration deciding to do judicially enforceable rules on regulatory analysis, because I think this isn't a crazy idea. There's actually a rule that's pending now from EPA that raises this issue. So the notion this isn't a real issue is, I think, a red herring. And I also think, like in my experience at OMB, there is gross non-compliance with the kind of guidance people are pointing to. Circular A4 from OMB, and there's also benefit, cost, and risk assessment guidelines from many agencies. There's information quality guidelines. I think there's gross non-compliance with all those things, and all you have to do is spend some time in the belly of the beast, and I think you'd say that. But whether or not people agree with that kind of a statement, I think what would be a real mistake is taking off the table the idea that an agency or administration, against maybe its own flexibility, might want to decide that it's important enough to have an evidence-based regulatory process where regulations rise or fall based on the evidence and not whatever the political, wherever the political winds are blowing, that they want to actually commit themselves to make this judicially enforceable. And I think what's going on in the case law, especially from the Supreme Court, also is another reason to think that this is a serious enough idea. It shouldn't just be sidelined. I don't think you should title this all about agency guidance, but you should leave open the possibility that an agency might want to actually embrace this.
I want to just work through the queue and then we can have responses. Erica?
Thank you. So my comment is somewhat related to what we've been talking about. It has to do with the terminology issue. I'd like to suggest that we consider whether adding this new term explainer, which then creates all sorts of challenges in terms of the definition and the scope, that might be introducing more complexity than we need to. I think there's enough terminology challenges here that adding a new term, the scope of which is a little unclear, may be more trouble than it's worth.
Would your preference, Erica, be something along the lines of guidance, the sort of guidance buckets that are in comment TR3, or did you have another specific idea?
I mean, it might be fine rather than to adopt a term that captures all of these things to sort of describe what we're talking about. There may be other documents, such as guidance documents, things that have a formal label of guidance document, or some other sort of informal page on the website that describes. I don't see a need to sort of adopt the term if we can simply say there may be other ways in which an agency might choose to communicate this information.
So it's sort of a residual category.
Yeah, yeah.
Okay. Jonathan Weiner.
Thanks. My comment or question was about whether the approach here in the preamble, and this would have implications later as well, should be to try to define the applicability of this recommendation on rules on rulemaking to a particular category. And we're talking about all these different cross-cutting categories, substantive or procedural, legislative or other types of rules, judicially enforceable or not, or binding on the agency in court or binding on the agency staff or something else, or other names like guidance and policy statement and explainer. So rather than trying to say, here's the subset that this applies to, what about an approach that would say, here are several options or paths down different branches of a decision tree, and the different agencies may choose different ones, and here are the implications, or here are the recommendations that the committee makes or ACUS makes about the maybe the merits of going down different paths, or the way that some of those should be treated as the rest of the recommendation will handle. So posing it more as options for agencies rather than as this is the one thing.
And do you have a view on the options sort of that are in comment TR3, the three buckets of guidance there, or do you have just a different preference for the kind of specific options?
I don't immediately. Let me look at TR3. I'll come back to you.
Okay. With that, I'm going to turn to Sid, who's been waiting patiently.
Thanks. It seems to me what we're talking about is a rule on rules, not a rule on rulemaking. And one could start with the APA definition of rule, and then we've got all these various buckets, as you say, that seem to qualify as rules, and we could point those out. In that regard, I'm not sure I understand whether explainers qualify under the APA definition of rule or not. It sounds like they do not. And if so, we can say there are non-rule ways of also imparting information about
if
your
I
rule.
just jump in really quickly, on page 2, so lines 15 to 16, the current draft says explainers. This is good for everyone. Can include policy statements, interpretive rules, and some documents that may not qualify as rules. So it does include rules under the APA that are not legislative rules, which we define as procedural rules or substantive rules.
Okay, fair enough. But I still think we're talking about rules on rules.
Sure. I just want people to get a sense of the different options and where how the buckets currently look. Comments on any responding comments to what we've discussed so far?
Connor, I think it might actually be helpful if I could just pull up the introductory paragraph of the memo, which recites verbatim the description of the project from the project page.
Please.
I think just to ground. So this is the memo that was circulated to the committee. This first paragraph is a verbatim description of what the website says, or near verbatim. There's just some stylistic changes, but so it says, well, you can read it. It's up on the screen, but I just wanted to remind everyone what the scope of the project is as decided by the council.
May I say something about the scope of the project? Reeve, jump in here if you think I'm misinterpreting anything here. It seems to me that the summary, and Todd, this is faithful to the website description, right?
Very much so, yes.
Very much so. It does, the project description here does refer to rules. It doesn't say what kind of rules. It doesn't say legislative rules. Rules here could be could mean could mean policy statements of the sort that do bind agencies internally. It could mean that as well. I do think that in some ways explanatory materials, call them explainers or whatever, explanatory materials could be addressed in the recommendation, but I don't think that's what's intended here by the term rule. Reeve, do you agree with that? Explanatory materials basically meaning something, say, on a website that explains generally to a member of the public or a prospective commenter how the rulemaking process generally works, what OIRA's role is, and so forth and so on. Reeve?
Yeah, no, I definitely agree, both with respect to that latter point, and then also the former point that, you know, that when we say rules, it doesn't necessarily, you know, there could be a variety of different rules, you know, including policy statements that would be binding internally. And I think, you know, something like maybe the approach that Jonathan Weiner articulates, where we sort of go through each of those, would be consonant with, you know, the intent of the council here. I think something like that, sort of laying out the different options and, you know, the pros and cons of each, you know, would achieve that goal and would maybe achieve the level of flexibility that, you know, the agencies would consider valuable.
I think it would be useful, Connor, if I know I'm talking here a lot. I sort of put everything in sort of three buckets here, just because to introduce yet additional terminology. One is a legislative rule of the sort that I think Paul Noe was referring to. The other is a policy statement, which is binding at least to some extent within the internally. And then the third category would just be explanatory materials. That might be one way to think about this. I do recommend, though, that the committee say something about rules on legislative rules in this context, and whether in some contexts they may be advisable. Obviously, the committee would probably not be very prescriptive here about the matter, and might, to some extent, or might disfavor any kind of widespread use of legislative rules in this particular context. Reeve?
But to be clear, Matt, when you use legislative rule, you mean as it's defined in footnote 1, which encompasses both substantive and procedural.
I am using legislative rule to mean, as Ron Levin has used it, for instance, among commentators, but more importantly, as ACUS has used it, to mean a rule that has the force of law. And it doesn't mean, somebody referenced that it creates a private right of action. It doesn't create a private right of action. It just means that if a case is properly before a court, all the justiciability requirements are in place, that a court should enforce it as a legislative rule. That's all I mean by it. Reeve, is that consonant with your understanding?
Precisely, that's consonant with my understanding, and I also agree that I think there's some value. You know, it sounds like there are at least certain instances in which agencies have, you know, issued such things, and to at least set it forth as a category. You know, we certainly don't want to push agencies down that path. You know, but acknowledging it as a distinct category seems like it has some value, without putting our thumb on the scale. You know, as to what paths agency might pursue. You know, they may consider that. They may consider a policy statement that's internally binding. They may consider explainers that are not binding on anybody.
And with respect to the sort of laundry list of topics that might appear in a rule, and I'll just say rule without qualification, those topics could be used either in a legislative rule or in a policy statement, which, you know, of course, is also a rule.
Terminology is slippery here. I want to just, we'll go back to the queue, I promise, but reactions to Matt's three bucket approach.
I have a reaction.
Please.
Like it more. So I like this. Maybe just a little gloss on it would be, we're obviously tripping on terminology quite a bit here, and maybe the way to avoid some of that is to just be more functional in how we describe what we're talking about. So it seems that functionally what we're thinking about is enforceability. So there's judicially enforceable pronouncements of the agency. There are pronouncements that the agency intends to be enforceable or binding for, you know, as an internal matter. And then there are explanatory materials that are, you know, that are not intended to have any particular binding effect, but which, you know, the agency believes to be its, you know, kind of current practices, and it's communicating those to the public, and then maybe just skirt some of these definite, like where a legislative rule falls in this, and the procedural versus policy statements and the like. I mean, these are all terms that come with a lot of baggage, both internally to ACUS and with respect to the courts, and it may be better to avoid them or to stick some of it in explanatory footnotes or something.
Further reactions on this point? Anybody should just jump in.
This is Steph. I mean, I think the important category that is missing from the bucket that Matt described is agency rules like the DOT rule that are promulgated in the Federal Register, but that the agency very clearly intends not to be judicially reviewable and includes an appropriate disclaimer as to such. And I think this judicial reviewability point has me a little bit hung up, in part because I do think that explainers might include, for example, interpretive rules, which could be judicially reviewable. And so, I personally would recommend taking the judicial reviewability issue aside and thinking about the different ways that agencies can promulgate the rules, and then or documents, whatever it is that they end up doing, and then just asking them to be clear about their intentions with respect to binding themselves on the public.
So, Steph, you would create a fourth category, which is material published in the CFR that does not hold the force of law, just to make sure I'm understanding. Is that right?
Well, I think that category, exists in DOT's rule. And again, it's up to courts to determine whether or not they would give effect to that disclaimer language. But, we have an example in the memorandum that Todd prepared for us, and, that the agency itself has shared, of an agency who has promulgated what it believes to be a procedural rule. It's put it in the Federal Register, and they include that sort of disclaimer language.
I just mean create for the purpose of the recommendation, not more broadly.
Well, I think it
why
should
do
be
we
in
need
the
a fourth
recommendation.
category? What's a fourth category here? Why isn't that just a policy statement that's published in the CFR?
Is that what it is, DOT? I mean, it looks like a rulemaking to me, but.
I mean, yeah, I guess.
But a policy statement is a rule. That's the problem here.
I worry that we're losing. I mean, I was only, speaking for myself, I was only involved in this a little bit here and there. But, I think this debate about whether or not it's a legislative rule or a policy statement, I think our leadership wanted to get this in the CFR and get it, established in that way. I think this debate that we're having is something that agencies don't always think as hard about as ACUS would. We had our disclaimers in there and they were explicitly clear. So those are part of it, and so is putting in the CFR. Whether or not it's a legislative rule or a policy statement, I mean, before we put this in the CFR, right, we had it in an internal order and in a guidance memo from the General Counsel. So in our view, those were just as binding on the agency, though not as probably clear as to the public. So that's why we wanted to put it in the CFR with all our other rulemaking procedures, not just, or our pre-existing rulemaking procedures that were wrapped into this. So, that question is just not really a question I think we were asking. Our view was substantive versus procedural, and obviously we said it was procedural and therefore it was not enforceable. But yeah, I tend to think maybe more practically, which is to say a legislative rule goes in the CFR and everything else, the interpretive rules, policy statements, et cetera, are guidance and go out of the CFR, or suppose arguably in appendices. But so maybe that's overly simplistic way of thinking about things, but I think that's reflective of the way that a lot of agencies think about things.
Could everybody please, yeah, Jeff, that's fine. Could everybody please mute? We're just getting a couple background noises, but go ahead, Jeff.
Yeah, so I agree with Steph that the judicial review aspect of this causes hangups. And we have two different examples of the DOE and the DOT rules on rules. DOE wants to make them binding and DOT doesn't. DOE wants to make them binding, and it doesn't really matter if you call it the agency or, giving rise to judicial review, because if it's binding, then people are going to take the agency to court on it. So that's the agency's choice. So I think it's and to meet Paul Noe's comment, if an agency wants to create rules that are binding on themselves with respect to cost benefit analysis or anything else, they can do this under this recommendation, and we shouldn't try to discourage them. But I think what we're really trying to encourage is more information about how the agency's going to be handling its rulemaking process. And just on the very bottom of the scale, to talk about the question of whether an explainer fits within the definition of rule. The definition of rule in the APA includes or describing the organization, procedure, or practice requirements of an agency. So if an agency is describing its practice requirements for rulemaking, then that's within the definition of rule. If the agency is just talking about how what the APA says or something like that, they're not describing their own requirements there. It's the APA that's requiring it. So if they want to go into some other sort of explanation, that might not be within the definition of rule. But I think we can finesse that issue pretty easily. So I like the idea of having the sort of 3 tiers, the sort of legislative rule, policy statement, legislative rule binding, policy statement non-binding, and other descriptions, other information. Just to go back to that title for a second, I mean, maybe Sid's Rule on Rules is a good title. It's certainly a snappy title, but I think what we're really talking about is, agency. I mean, this isn't my suggested title, but this is what we're trying to talk about: agency legislative rules, guidance, and other information about their rulemaking practices. That's what we're trying to capture, and maybe Rule on Rules does that.
I do have a queue here, which will go down, but any direct reactions to Jeff Lubbers? Okay, hearing none, let's go then to Danny Fischler, then Ryland, and then Don Elliott.
Thanks, Connor. I agree with the general framing that Professor Lubbers and Steph have laid out. I just wanted to flag for the group that as agency counsel, there is a meaningful distinction to me between a rule that binds the agency, potentially including the agency head and is in the CFR, and a rule that does that and is also judicially enforceable. They're 2 really different things, and I think that there could be reasons to do either one of them. And my hope is that this recommendation would acknowledge that they're both potential options for an agency to pursue. That's all. Thank you.
Thank you. Ryland.
Thanks. I agree with everything Danny just said, and I want to suggest that maybe instead of having these 3 or 4 buckets, that we think about this problem in terms of 2 different axes. And on the first axis is in what sense is this document binding? And I think what Michael Livermore laid out a moment ago was good. So is the document judicially enforceable? Is it merely binding as an internal matter, or is it a non-binding explanatory material? Then for the second axis, I think that can be, how is the agency making this document available? And here again, I think we have 3 options. 1, the document is purely internal and it's not available to the public except perhaps through a FOIA request. 2, the document is made publicly available. So essentially this would be a guidance document that an agency could post on this website. And 3, the document is publicly available and it is included in the Code of Federal Regulations. And I think what's helpful about this 2-axis framework is that it allows for recognition of what Danny just mentioned, that you can have a rule that is binding but not judicially enforceable, but is also in the CFR.
Reactions to Ryland's sort of 3x3 approach here.
My reaction, Connor, is that my reaction here is that there's a lot of consensus here. I mean, I think I think a lot of us, Jeff and so on, have been saying the same thing, basically. There's a little different terminology being bandied about here. But I think there's a lot of consensus here in terms of what we're talking about and the distinctions that we're attempting to draw. And Jeff, what Jeff said is and so on.
I like Ryland's approach.
Yeah, me too.
Yeah, this is Jonathan Weiner. Yeah, I like it too. And it's what Ryland and Michael Livermore said, and maybe others, is similar to what I was thinking about, laying out the options. And then the recommendation can say what kinds of criteria or transparency or whatever should correspond to each of those. That might be.
Other reactions on this, on Ryland's proposal?
I like it. This is Erica.
Me too.
Do I? Thank you.
Now, of course, Connor, if you're going to treat something as a legislative rule, it kind of answers the question of where, how public it's going to be. It is going to be public and put in the CFR.
Sure, under 552. Don Elliott?
Yes, I also, at the risk of having, too much agreement, I also agree with the last few speakers. I think it's useful to identify 4 different buckets with the different axes that people have talked about, whether it's binding and judicially enforceable, whether it's binding and not judicially enforceable, whether or not it's not binding, and whether or not it's for information only. I think some of the difficulty here has been created by the courts, which have said that even if an agency guidance document says it's guidance and non-binding, there's a multi-part test, including whether or not it is published in the CFR, that can allow a court to say that it is a legislative rule and judicially enforceable, even if the agency says it's not. So I would propose that the committee consider, in addition to identifying the 4 boxes that we've discussed, that the agency's designation of which box its rule should be in is either binding on the courts or should be given substantial deference by the courts. And I recognize that that's an addition, but I think the other difficulty lurking in the background is if you intend something to be information only and you publish it in the CFR, some court may say that, oh, it was the legislative rule. Just one other related comment on the terminology side. I think people are using the terms judicially enforceable and judicial review in inconsistent ways, and I would suggest that we just try to be consistent about that. If there is judicial review of the promulgation of the rule itself, that's judicial review. If the rule is binding and enforceable in litigation about something other than the content of that rule, I take that to be the question of judicially enforceable. And you can have one but not the other, obviously.
Any reactions to Don's addition on speaking to the courts?
He's right. I mean, Don is right, and if the draft recommendation the staff prepared doesn't suggest something otherwise, that was not what was intended. But I mean, I think that I don't read. You can speak for the staff, but that's what was intended. What Don, how Don just described it.
I think that will also make it much easier for the agencies to buy into this and do it, going to a point that people made earlier.
So do we have a sort of a broad, recognizing that there's drafting work to be done, a broad consensus on this framing as sort of laid out by Ryland? Okay, we'll obviously have another meeting. Okay, well, we'll work on drafting consistent with that discussion. And let's move on so we can give feedback on the rest of the preamble. So if we move on then to starting at really at line 29, where we talk about the policy considerations with respect to rules on rulemaking. And I will we have right now sort of considerations. So I'll just open up the entire section on policy considerations, lines 29 through 58 for discussion.
Mike Lemire, I have a couple of thoughts on this.
Thank you.
So I guess the language of kind of tying their hands I found to be a little strange, and maybe this is a small point, but it seems that we might look for better terminology there. I think the concern is the twofold. One is the kind of, so there's the excessive procedure concern. There's kind of what I take the tying their hands concern to be is something like inflexibility or an inability to tailor a procedure to circumstances, kind of overly general rules that aren't necessarily well suited to specific circumstances. And so this I think there's a discretionary point which I see Sid just raised. I think that's somewhat distinct. So there might be a kind of a third thing too, but I think excessive procedure and then distinct from procedures that aren't well suited to a particular rulemaking circumstance. And then just generally on the policy considerations, scanning them over, it seems that the balance, the impression is that the balance is in favor of doing these rules, and we may ultimately want to conclude that, but I think we just have to be careful in the wording here to make a choice. If we think collectively that the benefits outweigh the cost, then that's fine. But it's the way it reads right now is obviously pretty favorable towards adopting these kinds of rules. And in case that was just my quick impression.
Responses to Mike Livermore's comments. Sid, I think you have something on line 54.
Well, I wanted to respond to Livermore's comment.
Sure. Oh, sorry. Yeah.
I agree with Mike. I had the same impression that we were saying these things were always great and always had benefits in terms of efficiency and so on. And I went back and read carefully the background memorandum distributed to the committee for the last meeting. And I don't think it really supports that empirically. I think the most you could say is it says that some agencies have found to these types of rules to have the following advantages, but I don't think we can say, and I don't think we intend to say, based on what we say elsewhere, that these are always good for all agencies. So I would just refer to the Committee on Style, thinking about how we might tweak that language to identify the potential advantages, but without appearing to say that they always have all of those advantages for every agency in every situation.
Don, was there specific language that you had in mind?
For what was causing the problem, or how to fix it?
Either. Just any specific lines.
I would just say, which is what I think the backup documentation really says. Some agencies have found these types of rules to have advantages in, and then list the categories. Mm-hmm. But I don't think we've done a comprehensive review, and I do think that that's what makes it come across as if ACUS is really pushing this. And I think our intention is really, as Reeve said earlier, to get agencies to consider this and share the experience that some other agencies have found it valuable, but not necessarily to say every agency ought to have that. Now, if I'm wrong about the intention, and the intention is to say every agency ought to have these, I guess I would wonder whether or not we really have enough information to make that kind of a judgment. It's less of a problem if we create the 4 categories and say, agencies ought to pick one of the 4. I don't know whether I would oppose it or not, but I think to be accurate to the background documentation, we should say something on the order of some agencies have found such rules have advantages, in particular circumstances with regard to, and then list the categories.
Additional qualifiers. Reactions on that point?
Hi, this
Todd,
is
I don't
Danny.
think you intended anything more, did you?
Sorry,
Todd,
Matt,
you
we
didn't
had some
intend
cross.
anything more than what Don said, did you?
Were you asking me? I think.
I was asking Todd, who wrote the memo. I don't think he intended to make a more ambitious statement than the way Don Elliott just put it.
Yeah, that's exactly right. Don's statement captures exactly what I was trying to capture in the memo.
Danny, did I hear you or somebody else?
Yes, that was me. Sorry about that. I agree with the proposal, and I would further propose on what looks like line 34 on the share screen, and all the way down in between the words public and benefit on line 34, adding the word may or some other kind of hedging language, may in some cases, something like that, might also improve the connection between the recommendation and the underlying report. Thank you.
Sid, you have been in the queue. Sid Shapiro? Okay, Ryland.
Okay, I'm sorry. I was muted. Okay. So I want to bring our attention to lines 52 to 58 under costs and inflexibility. And there it's referring to this should not be an issue if the agency reserves an appropriate level of discretion. I found that a little bit confusing and vague. I assume what we mean is if the agency does not make this binding on itself, at least if not more widely binding. But it does seem to me this relates to the three categories we mentioned earlier, finally, as a way of sorting out what we're talking about. And we can point out that agencies have those choices between various ways to do this, and that affects the costs and flexibility that they have.
I think that's helpful. That ties into the conceptual framework of the project. We'll have to kind of edit with that in mind. Other comments on this section of preamble policy considerations?
This is Erica.
Oh,
Can
yes,
I just
go ahead.
ask? I had taken that sentence differently, and I just am curious. I assumed that what was meant there was not discretion in a term of art sense, but really that it shouldn't be an issue if an agency. It would depend on the level of detail versus generality in how in the weeds, to use sort of plain English, an agency was, as opposed to more general. That's how I took that sentence. So is that correct, or am I just way off base?
I can jump in, Erica. Yeah, I think that was our intent, is to sort of, basically the agency, it depends on how they phrase it, essentially. And if they, maintain, the flexibility necessary, then they can have it in a rule that, reserve the ability to depart from it in appropriate circumstances or something like that. Which
If that's what was intended, I wouldn't use the phrase appropriate level of discretion. Maybe appropriate level of detail or something like that.
Specificity.
Right.
Yeah.
The same issue is in recommendation 1. They use the same language.
Yeah, and I promise we're going to take a break here in a minute, and then we'll jump into the recommendations, acknowledging that we're going to be editing the framing in accordance with the buckets that we discussed. So before we take a break, Ryland, quick comment, and then Danny, and then Jonathan, and then we'll take a break. So Ryland.
Sure, I have a couple of comments. So my first one is I just want to echo Don Elliott and Danny Fischler's earlier comments regarding the benefits. I think it's important that the benefits are not overstated, particularly if we don't have empirical research that clearly says that this is actually a benefit. I'd also, I guess, want us to be nuanced in our language in terms of which of these benefits specifically attend legislative rules versus just the agency providing more information on its processes more broadly. I know I've made this comment a few times. I just want to reiterate that because, again, I do think a lot of these benefits accompany agencies, guidance documents or explainers more broadly. My second comment is about the last policy consideration on costs and inflexibility. We've spent a lot of today talking about judicial enforceability as well as judicial review. And I wonder if it would make sense to recognize that explicitly in that section, or perhaps list that as an additional policy consideration. So both judicial review in the sense that the document itself can be reviewed, as well as judicial enforceability of the procedures in the document in future actions. And I'll also note, my last just very minor point is that this discussion about that what we just discussed in line 54, this shouldn't be an issue if the agency reserves an appropriate level of discretion. I think yes, of course, agencies can reserve discretion either by making the language very broad or by not making the rule binding. But in either case, I think there is a specter, a possibility of judicial review, right? Courts sometimes do review an agency action under the arbitrary and capricious standard and rely on guidance documents or policy statements which are non-binding as sources of law to apply and can penalize the agency for an unexplained departure from those guidance documents or policy statements. So I think it might be worthwhile to recognize that as well.
Want to make sure we get to break. Danny, did you have an additional comment or did we cover you before?
Just an additional point. I agree with Ryland's comments just now. I would just add that this should not be an issue sentence. Just gives me a little heartburn because the committee is sort of describing a whole range of potential actions, judicially enforceable, just enforceable within just binding within the agency, explainers on a whole range of topics. And I think that the language could really be hedged or massaged a little bit. In many cases, this should not be an issue, something like that. I just wouldn't want the committee, I wouldn't want the recommendation to suggest that there's no, that there's no circumstance where an agency can't draft around the problem of cost and inflexibility. If we get to the point where we're vesting so much discretion that we're addressing all of the topics that we see in enumerated recommendation 2, for instance, we're probably going to end up with rules that aren't very helpful because the agencies are just going to be creating exceptions to them or draft them at such a level of generality that they're not helpful. So long story short, I would recommend hedging the start of that sentence. Thank you.
Jonathan.
Thanks. In looking at this section on the policy considerations, and especially in the last part about cost and inflexibility, on lines sort of 54 through 57, there's not only discussion of appropriate level of discretion, but also this word about can depart if necessary. And I think the word depart is also used in line 62, and it's also used earlier in the document. And it seemed to me that it would be useful to say a little bit more about what it means to depart, and perhaps what the costs of departing are. So it could be that the rule on rulemaking provides for exceptions in it, which is, I think, what line 56, 57 refers to, writing the rule on rulemakings in a way that ensures that it can depart if necessary. But in other places, it's referred to as a question of bindingness. That is, what would be the cost of departing without an authorized exception, such as internal discipline or judicial rejection. But then the question that I asked in our last meeting was, and maybe this question is a misunderstanding, but was, even if the rule on rulemaking does not provide for an exception or grounds for departure, couldn't the agency in the subsequent rulemaking, if it gives sufficient reasons, say that it's taking a different approach? Through notice and comment, subject to judicial review, the next rulemaking would stand on its own feet. So it might be helpful to clarify a little bit what it means to depart and what the downsides or costs or potential repercussions departing are in these different contexts.
Okay, thank you. And Steph, last comment, and then we will take a quick break and then we come back.
Yeah, thank you so much. I was just going to say that I think here in the preamble that it would be helpful to have some examples from all the great research that Todd did of where agencies have chosen to build flexibility into these rules to account for particular circumstances. So, unlike some of the policy considerations, this is an area I think where there is some empirical work that can be done to discuss what agencies have found to be appropriate in particular rulemakings or guidance documents that they have issued. So I would just encourage us to incorporate some of those lessons learned, because I think to an outsider who's reading the recommendation, there's real value in discussing when agencies have chosen to reserve discretion for particular types of issues.
Okay, thank you. I want to make sure we able to give feedback on the entire recommendation today. So we will, when we come back, start with recommendation 1. I see Peter Strauss has a comment queued up. So we'll start with recommendation 1 and say 5 minutes. So let's say 3:32.
Hey, Todd, I'm sending you and Matt an email about how important it is to, as a criterion, to publish something in the CFR. I don't know if you can hear me. Maybe you're not there.
Yeah, Jeff, I'm here. I'm just attending to a couple other things right now, so
Oh, okay.
I'll be right back with you.
I just sent the email.
Jeff, if you can hear me, do you want me to send that comment out to the committee? Hi, Jeff. If you can hear me, you're on mute, but I wanted to ask you if I should send your comment around to the committee.
I don't know if you need to. I mean, it's just basically saying, you know, people have been discussing whether or not if an agency publishes something in the CFR, that turns it into a legislative rule. And the American Mining Congress listed that as one of its 4 criteria in determining whether the rule is a legislative or an interpretive rule. But later cases, both in the DC Circuit and the Ninth Circuit, have sort of de-emphasized that criterion. And so in order to kind of reassure agencies a little bit that if they happen to publish something they don't want to be binding in the CFR, it's not going to turn it into something that necessarily is binding. So
right, that makes sense.
It's just for the next draft of your recommendation, you can maybe insert a note to that effect based on those cases.
Understood. Great, thank you for that.
Yeah, okay. Hey, Peter, how are you?
I'm fine, thanks. How are you, Jeff?
Pretty good, pretty good.
Good. Did anything happen while we're still on break, and you could tell me, did anything happen with respect to lines 4 and 5 of the recommendation that define rules on rulemakings as referring only to legislative rules?
We had a lot of discussion of that. And Ryland Lee came up with a sort of a two-axis test to create the categories of rules that we're talking about and the procedure that agencies use to issue these rules. So everybody seemed to think it was a good explanation of what we're trying to talk about here.
It's actually the explanation, Jeff. It's not just Ryland. It's the conception of the project that Peter Strauss put on the table in the first 5 minutes of the last meeting. We just keep getting hung up on the terminology here.
Right, but I mean, we did have a long discussion of those issues at the beginning of this meeting when Peter wasn't there.
I know we did.
My reason for asking the question has to do with the comment that I will make about depart. If the rule is in and of itself intended to be a legally active, legally enforceable, as it were, proposition that is binding on the agency, then depart really isn't the right word to use.
Well, that's a good segue. We can, I think, just jump back in. I think that's more than 5 minutes. So yeah, Peter, at the beginning, we talked about creating a series of buckets, one of which would be legally binding rules, another would be those binding only on lower level agency staff, another would be more like an explainer. And so the recommendation would contemplate sort of different status. And so we do acknowledge that the recommendation will need to be redrafted with this new framing in mind.
Okay, so in the second of those buckets, which you know I like, which is not enforceable in the same way that the first bucket is enforceable, depart doesn't create the same kind of problem. But if we are talking about a proposition that is intended to be binding in the strong sense, not that the agency can use it for discipline or the like internally, but that it can be enforced from outside, then the rule itself has to provide for the possibility of an exception from that particular thing. And I don't think that could be described as an appropriate amount of discretion to depart from these rules. Because then you're saying, oh, it's not a rule. If you have discretion to leave it, it's not a rule in the first sense.
I think that's
helpful. You may
helpful.
not need to talk about to depart from these rules, but just say agency rules intended to have legislative effect should preserve an appropriate amount of discretion for flexibility in appropriate circumstance. This may entail not committing to a particular procedure or drafting the rule in a way that leaves adequate discretion. I just, depart struck me as, on the one hand, you're saying it's law, on the other hand, you're saying it's not law.
Sure, yeah, that's a helpful start. And we're redrafting this as consistent with the new framing in the preamble.
Okay.
Other comments on recommendation 1?
And then I have some on recommendation 2 as well.
Yeah, I imagine. And recommendation 2 we'll have in a second, but anything else on recommendation 1?
I have a comment on recommendation 1.
Yeah.
So I understand that there's going to be some redrafting done to accommodate the new structure. I guess I would also suggest that maybe we make the language a little bit more discretionary and say something like agencies should consider adopting these rules as opposed to agencies should adopt these rules. And I think that's reasonable in light of the earlier discussion that we've had where folks have said, we're not saying that every agency should always adopt a rule on rulemaking, especially not a legislative rule on rulemaking.
Follow-ups on the should consider it line 59 of what Todd circulated.
This is Erica. I agree completely.
Other reactions?
This is Don Elliott. I got in the queue just to make that same point. I think it's consistent with the discussion we had in connection with the preamble that the background report doesn't really support a statement that agencies should adopt rules in all rulemakings for purposes of promoting predictability. So I think we need to tinker with the language a little bit to either say they could consider it or something else. But we already made the change in the preamble. We should make the change in the recommendation consistent with what we say in the preamble.
Steph Tatham.
Yeah, I agree with that. And, I would say that it's not just rulemakings that can serve some of these values. So you could have a guidance document that promotes efficiency by setting forth the agency's internal procedures, or that if it's publicly shared, and apologies, my cat's joining the call, promotes transparency. And so I would just encourage this to not focus specifically on rulemakings, although if it did, I do favor the should consider language, but to say, these are the factors agencies should consider as they think about which form of policies or rulemakings they end up promulgating with respect to rules.
Yeah, this will be redrafted consistent with the preamble. Bill Funk.
I would just like to suggest that the Department of Energy's rule on rulemakings is not a general rule on rulemakings. It's specific to one category of rulemakings that they're making their rule. And I think part of number 1 could say, make a general rule or a rule as to subset of rules. There may be a particular subset of rules that needs this kind of guidance, but not others.
Under a particular statute or whatnot.
Yes, exactly.
Okay. Reactions? Okay, well, that's all helpful. Let's move on to number 2, which is our long list of different potential provisions of a rule on rulemaking. So welcome reactions on anything up to line 110 of what Todd circulated. Recommendation 2.
May I speak?
Yes, please.
So it is a long list, but it strikes me that there are a couple of omissions from it that I would hope would be supplied. In the lead up in 68 to 70, you say agencies should note that this menu draws from existing rules on rulemaking, many of which include these procedures to implement statutes, executive orders, or previous recommendations of the administrative conference. But I may have missed it, but I don't think rules to implement executive orders appears in the long list, and it seems to me that it should. You've said that in the preamble, 1, 2. The executive orders in relation to rulemaking are about the most important things there are for really significant rulemakings, and the public is entitled to know how that works within the agency. So that's one, and another comment is not on the list is the making available of underlying data and reports, which that is the Portland cement, Kennecott copper kind of requirement. That, it seems to me, should also be there. And finally, there's no reference here to the agency's use of regulations.gov. And that seems to me also to be a useful addition to the list.
Reactions to any of Peter's additions?
I actually have a question about Peter's addition. So as far as procedures to implement executive orders, Peter, I was just wondering if you could maybe explain more on what you have in mind there and how this list currently doesn't capture that.
Well, procedures for getting things on the regulatory plan. The internal procedures for compliance with Executive Order 12866 and 13771 in whatever form that may take in future times.
So would you specifically mention the executive orders within the list?
I would, it would be sufficient to satisfy me to say something about engaging with governing executive orders.
I think there are some things on the list that do come from executive orders, like D and O and Y. Those are things that kind of stem from executive orders.
Yes, but they don't, how can I put it? The rule on rules, and maybe people will think this is just better for explainer than for the rules. But the rule on rules is supposed to indicate to the public the way in which rulemaking occurs. And the lack of a specific reference to the way in which executive orders are dealt with, maybe developing entries picks up one bit of it, but there's nothing in the list that suggests the connection to OIRA.
Very end on the next page.
Steph Tatham, I know you had written on this point, so I'll recognize you.
Yeah, I wanted to make a sort of different point than we're talking about now, which is that I think this is a really helpful list and I appreciate the level of detail, but I also worry that it appears as if it's exhaustive when it may not be. And I'm wondering about its placement in the recommendation. And, you know, I wonder if it might be more useful to sort of bucket the different things that agencies could address in their rules on rulemaking, and then maybe have in the preamble or in appendix this more exhaustive list of things that they might consider doing, or alternatively just being very clear that this isn't intended to be exhaustive. You know, in terms of processing this information, it's just a laundry list and it's a very valuable one, but it's hard to grasp, you know, whether or not these things are related, if agencies might want to discuss them in the context of other things. And so maybe just thinking about bucketing them into general categories and than having a more exhaustive list of what might fall under particular categories or whether something could fall under multiple categories, I think would be useful.
Reactions to that general structural point.
I have a reaction. I think, this is Jeff, I think it's might be helpful. I think the list is might seem a little scary to agencies because it's so long. We went through the whole alphabet, sort of like the hurricanes. We're going to have to start using Greek letters next. But I think maybe putting them in buckets would, if we could come up with 4 or 5 types of things, that might seem a little better. So I kind of agree with Steph's point in a way, although she was concerned that it not be exhaustive. I think it might be exhausting. But I also wanted to add something too. So in I didn't quite understand, including whether to establish minimum comment periods. I mean, I think, you know, I don't know what we're telling the agency to do there. I mean, the agency is going to have to tell the public what the comment period is in each rule. So I don't really understand that. I know it's intended to be in juxtaposition to K, but still, I think there must be a better way to say that. But I was going to say, or reply comment periods in J, because I think that's something that ACUS has recommended agencies consider, and it would fit in there if we can figure a way to rewrite it.
I'll chip in.
Minimum comment periods. I took that to mean sort of across rules, not specific individual rules. But Todd, let me know if you had a different meaning.
That was the meaning, Connor, across rules.
Peter, did you have a direct reaction to Jeff?
No, I had a reaction to your, how do people feel about Steph's comment.
Okay.
Buckets, and I would suggest you do it in effect on a timeline, right? One bucket is a bucket about getting to the point of deciding to engage in a rulemaking. Another bucket is about, okay, the notice and comment period. Another bucket is about how the agency deals with comments once received. And I think that would be helpful for agencies seeing these as discrete and manageable things, and not an extensive list of what this and that and that and that.
Yeah, chronological buckets. Sid.
Right.
I was going to recommend combining K and O, but that would also make for an appropriate bucket. And the reason for that is we say, as to the public, we may want to use means other than notice and comment rulemaking. Then following the executive order, obtaining feedback from various other groups that are maybe more marginal or under-resourced. And it is, as to those groups, you especially might want to use alternative procedures. So maybe that all could go together.
Does anybody have reservations about bucketing or additional concerns about bucketing? Okay, hearing none. Jonathan, did you have some additional thoughts? Jonathan may have left, I may have seen. Rylan.
Sorry, I was trying to hit my mute button. I had 2 comments. One is a question for clarification, and the other one is more of an observation that I value people's thoughts on. So the first question is about F, preparing for potential judicial review of rulemakings, including deciding whether to make any of the provisions of a rule severable. I was just a little bit confused as to what that meant, and if the intent there was that agencies should explicitly say in every rule whether the rule is severable, or if that refer to something different.
This is based presumably on a prior ACUS recommendation, the report for which Don Elliott had written. Reeve, I don't know if Connor was around then. Do you just want to explain this and what the provenance of this provision was?
Sure. So yeah, it absolutely is referring to that prior recommendation, and essentially, the upshot of that recommendation is that agencies should consider, in particular rules, giving thought to whether or not they intend the rule to be severable, if part of it is struck down on judicial review, and if so, try to structure the rule in a way that they're not just throwing in, a catch-all clause at the end, that they're actually giving thought to sort of whether or not they intend each separate provision to stand, and if so, articulate in some detail how that works. So we're simply referring to that past recommendation and incorporating it as one possible thing that the agency as part of its rule on rulemakings is how it intends to do that.
Thanks, Reeve. That's helpful. I was not aware ICUS had that recommendation, or maybe I was and I forgot about it. So I wonder if it would be helpful to include that maybe as a footnote or in the text, just so people reading this will understand that it's referring to that. My second comment was a broader observation that I'd be curious to get folks' thoughts on. As I went through the list, it occurred to me that in some of these areas, there's already quite a bit of guidance that's available. So for instance, if we look at for instance, waiving or revoking the APA exemptions and notice and comment, there's already a great deal of case law about that. I'd say the same thing for T. There's a lot of case law on how effective dates for rules are established. Similarly for D, developing entries for the reg agenda. I believe there is already an OMB guidance on reg agenda entries. So I guess in general, it feels like for some of the items on the list, there may be a greater need or just greater benefit for agencies to provide more clarity on how they'll do a certain thing. But for other items, it seems like there already is a lot of guidance from either case law or OMB or some other source. I understand the list is meant to be kind of a comprehensive, or maybe not comprehensive, but a big menu of options that agencies can think about. So I'm not sure if it really makes sense to weigh in more on each of the options, but I just wanted to put that out there and see if folks had any reactions.
Todd, when you were surveying the rules, did you see some of the rules sort of try to synthesize requirements from case law or sort of summarize OMB guidance requirements, or did you see them sort of trying to make sense of what's out there in some of these areas?
Definitely yes. And so for R, for example, this came straight out of HUD's rule, and from what I remember off the top of my head, where they have waived the exemptions to notice and comment for rules related to loans and grants. So they put those through notice and comment. Other agencies specifically invoke the exemptions and say that we are not going to put those kinds of rules through notice and comment because the APA allows us not to. So that was just trying to get at what agencies have already said in their rules that, and then I guess with respect to, things that come out of EO 12866, like the unified agenda. Yes, of course, there are some detailed guidance for requirements that agencies have to abide by in those executive orders, but nonetheless, there still is a lot of discretion within those requirements, and agencies do attempt to fill in those discretions through their rules. So that's just what this was intended to capture, is existing agency practices, and yeah, so that's for sure.
Thanks, Todd. That's helpful.
Jeff, you had a quick addition. Jeff Lovers.
Yes. On why, since Charlie Maresca is not here, I think we could probably add the Chief Counsel for Advocacy of the Small Business Administration in there. And I also thought of another point, which is something that Peter mentioned. I don't want it to get lost, which is the relationship with the regulations.gov portal, because maybe more broadly, how the agency will accept and archive comments, something like that. because some agencies use their own website to accept comments as well as regulations.gov. Some only use regulations.gov. I think the FCC doesn't use regulations.gov. So I think that could be added.
Todd, did you see that in your research or survey?
Yeah, I mean, I did. I think that the challenge here is the level of generality we want to get to. So these get to, you know, these are specific aspects that I think fit within what's currently W. And we can certainly call attention to them specifically, but there's going to be there has to be some judgment call as to the level of generality. We're going to be bucketing these things. We have to keep it to maybe 5 categories. We have to keep it at a fairly general level. And in drafting it, it's, you know, that's the real challenge. So I would just encourage the committee to think about that.
Yeah, I think W is fine for the archiving one. I was just more about the how they receive comments part, which maybe making J, that could go into J.
Peter, let's make that, Peter can speak on the last comment, and then we'll move on to 3 and 4 so we can make sure we get through the entire recommendation. So Peter. An incorporation by reference, Peter Strauss. Peter, I think you're muted.
There we go. Okay, so D is developing entries for the unified agenda of regulatory and deregulatory actions, and I wonder if that's the reference, or rather the reference ought to be what the executive orders control, which is in effect the regulatory plan and and maybe you would say on the regulatory budget. And then I just wonder what the committee intends by incorporating standards by reference. As is well known, I have some views on that general practice, but there's an awful lot that could be involved in that, including agency participation, agency use of the database from the incorporated standard, agency making the standard available for comment during the comment period in some read-only form. Just to say incorporating standards by reference, I think will not be terribly helpful. And it may be that not only here, but in a number of other respects, the simplest thing to do, or the appropriate thing to do, is after listing it, incorporating standards by reference, parenthesis C, recommendation, close parenthesis. And just do that. You can do that throughout, and that would be helpful to the person at the agency who's trying to figure out what ACUS's position on this is.
I should say thank you to Todd for surveying and Reeve for surveying all the prior recommendations and pulling this list together. I know that was a lot of work. Let's go on to recommendations 3 and 4. And when we look at these, I want to say we understand the first sentence of each will probably need to be significantly reworked in light of the framework that we discussed earlier today. So we do understand that. But if you have comments kind of on the second sentence of each one, that and what we might say in a redrafted recommendation, comments on the second sentence of 3 and 4 would be helpful.
This is Steph. Yeah, I agree generally that for 3 and 4, I guess I would hope that they would be reframed, and that for the full list of things that are presented or the buckets of issues that are presented, the agencies are encouraged to consider what format to promulgate those in. With respect to the specific recommendation under 3, I guess I do have a little bit of heartburn in looking at a recommendation for each of the agencies to put out something in guidance describing the presidential review process and how the agency interacts with OIRA if applicable. I could see 50 different documents all being slightly different, and that creating some public confusion as opposed to providing a clear description of the OIRA process, which I believe to already be available in Executive Order 12866 and other implementing executive orders. So I would recommend striking that particular discussion, but I do want to be clear that I support the goal of agencies being transparent about their interactions with the Office of OMB and the presidential review process. So my goal is not to, not be transparent about that. Certainly Executive Order 12866 has transparency requirements. We host reginfo.gov to tell the public which members of which regulations are under review. We invite them to come and meet with us under Executive Order 12866. So very much supporting the goal of transparency, but opposed to the idea of 50 different agency guidance documents describing interactions with OIRA.
Jeff has a quick comment on 4.
Just that I think average number of days isn't quite right. Maybe say typical number of days for comment periods. And then again, the last clause, I find that that's the same point I made a few minutes earlier. It's a little bit, so we need to revise that the same way we revised the previous part.
Erica.
Yes, this is about the final sentence or the second sentence in 3. I think structurally it sounds exhaustive and therefore restrictive. It says these explainers can A, B, C, and D, which I don't think we intend to imply that those are the choices and the only choices. So it may be nothing more than adding in sort of an including or something, or such as. But
among other things.
Yeah, exactly. That's fine.
Danny, you have a comment on 3 and 4.
Yeah, thank you. With respect to 3, I actually had 2 points. With respect to Steph's proposal as to the end of 3, there seems to be a similar implication in 2Y and 2Z potentially. So I just wanted to flag that whatever is done there might need to be mirrored in 2Y and 2Z. I understand the context are different, but they refer to the same topic. And I don't know if Steph wants to respond to that at this point.
Sure. I think one thing that causes me a little less heartburn about its current location in 2Y and Z is that those are rulemakings, and so my office would more naturally review those as opposed to the agency website postings about the different presidential process. But I do generally have concern if agencies have very different descriptions of the same sort of process, and I would have to take back whether or not we'd be amenable to something being directed at us that we could put up on reginfo.gov. But I certainly support the goal, and I think agencies might want to explain to the public, hey, we have a rulemaking process, but part of that process involves presidential review, so the rule isn't going to be issued right away, and look, you can participate in that process. So I do see some value to having some information.
Any reactions directly on that? And then I know Tim has something, a clarification.
If I could say something on that, I mean, as a member of the public who follows rulemakings and interactions with OIRA, I would be very interested to know how the agency views its interactions with OIRA as opposed to how OIRA views its interactions with the agency. And the fact that there would be different responses within an agency as to how it deals with OIRA, I don't see that as confusing. I see that the fact that different agencies act different ways. Certainly OIRA is supposed to work in a particular way, but I think there's a real value in hearing how the agency interacts with OIRA involving the presidential review. To what extent is there informal communications? Nothing wrong with that, but should it be transparent that it happens at all?
Tim, did you want to speak to references to OIRA and your DOT reg?
Yeah, so there are basically more than 3 in number, but 3 sort of in spirit. One is to clarify that my office within General Counsel's office is the primary contact with OIRA for interagency review, for review of our rules, and for the agenda process. That's sort of the internal management process to keep everything within the Secretary's office to make sure that there's more finite points of contact with OIRA. The other is we have a relatively comprehensive discussion about how to handle meetings held under Executive Order 12866 review, which OIRA hosts on our rules, and how we're supposed to approach those, who's supposed to attend, and our process for that. So that's about how we deal with OIRA, nothing to do with OIRA's meetings themselves. And then throughout the document, there are numerous references to consulting with OIRA, and that's because those references are generally about if we're thinking about taking a particular action on a rule or wanting to do, for example, an interim final rule without comment, they say with consultation to OIRA because that's part of the interagency review and designation process. So we didn't really get into OIRA's role exactly, other than some references to 1266, but I think hopefully did provide clarity about which office is primary contact with OIRA, and then also how we handle those 1266 meetings. And we actually include a quick discussion. If anyone here has been to a DOT 12866 meeting, we actually reference our process at the beginning of the meeting, just the way OIRA references its own process. So that's how we handle it, and I think that helps the public without interfering with OIRA's central role in the interagency review and managing that review.
That's exactly what I would like to see. That's exactly what I would think should be there.
Jim Tozy. Additional thoughts on 3 and 4.
Jim has
Neil, did you have something? Neil Eisner?
I got it now. Can I speak now?
Oh, sure.
I'm
yeah, sorry.
I saw this issue of what they speak to OIRA. It's one thing for the agencies to describe the process by which they communicate with OIRA, but I think it's beyond the scope of this project or ACUS to address the issue of whether the substance of those meetings should be discussed. This has been an issue that's been around for 40 years, and it's always come out that any substance of those discussions are deliberative and they're not to be disclosed.
Any disagreement on that point? Neil, I think you were. Yeah. Oh, agreement. Yeah. Neil, I think you were. You had something. Neil Eisner.
Yeah, I don't want to disagree with you.
Neil, it sounds like we're getting some feedback maybe from your speaker or mic.
I earlier in the discussion. If we're taking any position on whether we would like to see agencies like OMB or
maybe you can put it in the chat.
Yeah, it's hard to hear. I think if you put it in the chat, I'm happy to read it. Neil, I'm sorry.
Or close video to get more bandwidth.
It's on the right, kind of the bubble. While you work on that, Neil, other comments on 3 and 4?
I think one problem is you might be logged in twice because I see you in two different boxes on the screen.
Neil, if you want to type it up, I'm happy to go back to it. But in the meantime, comments on number 5 with respect to publicity. And this is one I think where we can refer to all the buckets in the first sentence. So I think we'll edit the first sentence, but other comments on the remainder of number 5.
This is Steph. I'm sorry, I'm trying to pull up my draft of the recommendation. It's available in I support number 5. Sorry, I have a comment on 6, so I'll wait.
Jeff, number 5.
The last sentence, again, talks about it, but are not intended to be enforceable against the agency in court. So I think we're going to have to revise that based on our organizational framework. But also, there's just to give you an example of why this might be a little confusing is if an agency sets forth an explainer, in its explainer talks about, it has to give 30 days comment, it has to wait 30 days before it's effective. All these things that are in the APA, those are obviously enforceable against the agency in court. So even in the explainer, the agency might just kind of refer to some APA requirements. So it's another reason not to focus on the enforceable in court aspect, I think. And while I have the floor, I just want to say something in 6, which is
Jeff, if we could just hold off, I just want to finish 5 real quick. I'll be happy to go back to it, I promise.
Okay.
Additional comments on number 5. While we're waiting to see if anyone, Danny, I'm sorry, I missed you. I hate to go back, but do you want to jump back to number 3 very quickly?
Sure, thanks. I was just wondering, is there a benefit to having 3 if we're sort of collapsing the concept at the beginning of the recommendation as we had discussed? Like, are they not sort of the same thing, or is there some kind of distinction between the explainer and the options that are available under 2 as it's intended to be revised?
That seems like one we want to think about on the redrafting as we kind of step back and look at the whole thing. But if Todd, Reeve, or Matt have something, I think it might benefit from time to just reconsider.
You have to look at 4 also then.
Yeah, exactly. We're going to look at everything anew. We just want to get feedback on the ideas that are here right now since we have everybody.
Okay, thank you.
Additional comments on the substance of number 5. Okay, hearing none. Jeff, you had a point on number 6.
I know Steph does too, but this is a trivial one. I would say something like where it says on 135, within their notices of proposed rulemaking, within the preamble portion of the notices of proposed rulemaking.
Mm-hmm.
And this is Steph. My comment, I think, relates to, what I thought was an excellent comment earlier in the committee meeting, which is, could an agency propose in a subsequent substantive rulemaking to deviate from its procedures for rulemaking? And I think that they could. So I guess I am a little worried about the potential confusion here. If we're telling agencies to always cite to their rules on rulemaking in a proposed rule, is that going to then invite comment on the rules on rulemaking where the agency maybe isn't intending to do that, that instead is just intending to provide background information on its rulemaking process? And so I think that the wording here is honestly a little bit prescriptive and specific. Agencies should cite their rules on rulemakings. I think the idea is that when agencies publish rules, they should provide the public with information about their process, and the details of how they do that, I would want to leave to the agency.
Any reactions on the citation at that point?
Just say I agree with Stephanie for the reasons that she mentioned, and I'll also note that agencies often rely on legal sources and rulemakings that we don't necessarily cite, right? Like we might offer notice and comment because of the APA requirement, but we're not necessarily citing that section of the APA in each rule. So I wonder if it would make more sense to leave this up to the agency's discretion and reword the language to something like agencies should consider citing or something like that.
Todd, was the citation point something you saw in a number of rules on rulemaking or have seen in practice?
No, I haven't seen it. I think, you know, I wasn't looking at proposed rules or rules that cited rules on rulemakings. I was just looking on rules on rulemakings themselves. So I don't know to what extent this happens. I can't say one way or the other.
Anybody wish to speak in favor of including 6 roughly as drafted with respect to citations?
I would ask DOT whether they would see usefulness in doing that, since they have such an extensive rule on rulemaking. Would they see purpose in citing it in future rulemakings?
Hi, Jeff, this is Tim. Yeah, we cite it in our, we tend to do it in the same section in the notices part at the end of a preamble that we cite 12866. So, and we've actually cited our pre-existing order that existed in from the 70s too. So we kind of just replaced the reference, sort of saying this was done consistent with the DOT rulemaking processes, and we changed the reference, but it's consistent with what we've been doing for decades.
Have you ever had the sense that it's useful or not useful for commenters to see the site, Tim?
I mean, it's hard to know, right? I mean, it's in the back part with the boilerplate. That's in it says it's in every rule. I mean, it's probably helpful in the sense that, especially when we had the transition from our old order to the new rule, for people who weren't aware of it, if they were looking, although if someone's reading the boilerplate of a rulemaking, they're probably someone who's aware of our procedural change. But I mean, for our purpose, it's important to be clear that, you know, we do our rules as much as we try to do so, consistent with our procedural requirements that are in our prior order and in our rule. So I mean, I don't know how useful it's to the commenters, but we find it's important to, you know, emphasize that we have our internal processes, and just the way that 12666 governs interagency review, we have our own now rule that governs the departmental review process.
Thank you. I don't want to forget Neil Eisner, who types in the chat. I want to ask whether agencies such as OIRA should be doing the same thing with its processes for implementing rules.
This is Steph. I'm not totally sure I understand the question.
I think that's a different project.
Yeah, I think that's outside the scope of this project.
Any other thoughts?
It's not outside the scope of the project if we're just talking about rules that OMB is going to be issuing about its, you know, if OMB issues its own rules.
I don't think that's what Neil was talking about, was he? Maybe I misunderstood.
No, I don't think he was.
Neil, I don't know if your audio is working better. Did you want to say anything further? Okay. Well, Neil, happy to discuss further on email. The last recommendation, number 7, my own sense from the committee discussion last time was that the last sentence was causing people to get tripped up, and my own sense was it wasn't necessary, but it's obviously the committee's decision. So we welcome comments on number 7, including the last sentence, but your thoughts on number 7.
This is Michael Moore. My instinct would just be to strike number 7 altogether, or to say something a little bit more general about, you know, ensuring adequate opportunities for public comment and, you know, deliberation or something like that. Like whether the notice and comment process is the appropriate process or not, I think is, I don't know, it just seems too general. Of course, it just says should consider, but maybe the agency should consider alternatives to the notice and comment process as well. So it seems like there's a couple of different options here that the agency might want to think about.
Especially in light of the new framework, which is going to introduce, I mean, notice and comment's different than whether or not it has the force of law, but the new framework may address this to some extent. But Steph and Bill Funk.
Yeah, I just wanted to point out that we have recommendation 92.1 on point, and the first recommendation in recommendation 90, I'm sorry, the second recommendation discusses rules falling within the procedure or practice exception to 5 U.S.C. 553BA. And the conference does have precedent recommending that agencies should use notice and comment procedures voluntarily, except in situations in which the costs of such procedures will outweigh the benefits of having public input and information on the scope and impact of the rules and of the enhanced public acceptance of the rules that would derive from public comment. So really just wanted to note that we do have prior precedent here, and I think that we should discuss it in the preamble. And maybe we want to reconsider it in this recommendation. I don't have any particular concerns with the idea of agencies taking comment on procedural rules. I think there are a lot of good reasons for them to do that, but I want to make sure that we are cognizant of our own history here.
Bill Funk.
I think that's why this was put in, wasn't it, Reeve? To incorporate that very recommendation that Stephanie alluded to.
That's precisely correct.
My comment was sort of minor. I thought we should delete qualify as procedural rules that, and just have it read rules on rulemaking, even if they are exempt from that process, because they might be considered statements of policy that also would be exempt from notice and comment requirements. So I just didn't think you needed to call them out as procedural rules. Just say use notice and comment or other public involvement procedures, even if they aren't required to go through notice and comment.
Reactions on that point?
I think we should definitely flag the procedural rule exemption as well as the policy, the guidance exemptions.
Jeff, what about other exemptions?
Ryland?
Thanks. I wanted to say I agree with Michael's earlier comment about saying something more general about providing opportunities for public engagement, including alternatives for notice and comment. And I also want to agree with the TR4 note from Connor, suggesting that we delete that last sentence. I know we already talked about this last time, but if a rule has both procedural and substantive elements, I think an agency has discretion to not do notice and comment on the procedural portions, and I think there can be good reasons for that. And I'm concerned that the text that's drafted could just be an incentive for agencies to split a single rulemaking into two different rulemakings and incur more procedural costs, which wouldn't really seem to benefit anybody.
Yeah, this is Jeff again. I didn't mean to be so dismissive of the previous comment. I think the two exemptions that would be most likely to be invoked here are the procedural exemption and the statement of policy exemption. So that's why I kind of singled those two out would single those two out for mention here.
And you don't think the internal management one would be relevant?
Okay. It's just the difference between the management one and the procedural one is, I mean, there has to be a difference. So maybe it would be. I'm not opposed to adding that. I think the general point, though, is that is that even if the agency feels like it might be exempt, they should consider using the notice and comment process. And ACUS has said that essentially with respect to the procedural rule exemption already. I think we've said it, ACUS has said it on some other ones too, so those could be added to the preamble.
This is Ryland again, and so I have not read recommendation 92.1, and perhaps I should go do so, but if folks are interested in keeping the last sentence, perhaps a compromise would be to say that the agency should consider subjecting the entire instrument to notice and comment instead of just saying we should subject the instrument to notice and comment.
My comment wasn't addressed to the last sentence. I'm happy to get rid of the last sentence. It was more directed to the first sentence.
This is Steph. I would also speak in favor of striking the last sentence. I think it's up to agencies how they want to structure their rulemaking, and if they choose to mix procedural and substantive elements, I think that's really a matter for them. But the fact that they did so doesn't impose notice and comment requirements. Like what I think this recommendation should really be about is if we believe notice and comment is appropriate for procedural rules or agency management rules. And certainly in certain circumstances, I think it would be appropriate, and we have prior recommendations on point.
Connor, I think you might be on mute. We're not hearing your audio. Yeah, it's still muted. Jennifer, could you reach out to Connor and try to resolve this? It sounds like there's an audio issue. I'm not hearing anything.
Connor, can you just nod if you could hear us? We can't hear you.
You might have to log back on to go to meeting.
I can hear you now, Connor. Oh, sorry, that was Jeff. Sorry, I thought that was Connor speaking.
But let's just let the staff take care of the technical problems here. Todd or Jennifer, is it better to tell Connor what to do if you have to call him? Maybe he should call in maybe he should sign in, maybe he should call in. Let's just take care of this technical problem before we move on here.
Yeah, Connor, we should have you call in. I'll send you the number.
He has commented in the chat in the meantime.
Yes, and suggested that we're done.
I don't think we're quite done. No, I don't think we're quite done. If Connor can't get on, I'll just take up my last item of business, which I think is important, and which is to make sure that Reeve, why don't you turn on your mic here too and jump in here, and let's give Connor a chance here because he's the committee chair. But I do want to make sure it's clear what the staff's charge is, so that when we walk into the next meeting, we're not revisiting issues that have already been put to rest and so on and so forth.
Connor, if you check your email, you should see the call-in number in there.
Can everybody hear me now?
Yes.
Very sorry, but I don't know what happened. I did not press any buttons. So I was going to say, I was just going to ask the ACA staff what else they wanted to get feedback on while we had everybody, and then close. So Matt, I think you had something on your list.
Well,
Sorry about that.
here's the main thing I have, and I think this requires the full committee to be involved. You have referred to several times to the new framework for this recommendation, which I have an understanding of that, which I think was prefigured in Peter Strauss's comment. I keep saying that in the first 2 minutes of our last committee meeting about the different the different forms that these rules can take. But I think it would be useful if if the committee can make it very clear, ideally through you, Connor, what the staff's charge should be by way of preparing the next draft of the recommendation, because we don't want to be freestyling on our end. Is that? And I'm wondering if that could be done very, very simply without getting into a whole lot of caveats and nuances and distinctions. Reeve, do you have any? Do you agree with me that that would be helpful?
I absolutely agree. Yeah, I think that'll make our charge on the staff a lot easier if we can sort of get general consensus on, what we want the framework to be. It'll make it much easier to draft both that and then, the follow-on recommendations that derive from that.
The way I understood it is that we would sort of have a 3x3 box, and so on one sort of dimension would be to what degree is it public and how is it public, and so do we have it published in the CFR? Is it on the agency's website, or is it non-public? And the other dimension would be similar to what you said, Matt. Does it hold the force of law, or is it internally binding on lower level agency staff, or is it sort of an explanatory material? That's how I understood it. But
let me ask you this. I'm wondering if there's a way that I understand that's a nice typology or conceptual framework. I'm wondering how that sort of comes out in a recommendation and whether that's just too complicated, and whether it might be just better to talk about rules on rulemaking and to say that they can basically take two forms or maybe three forms. And one form would be as a legislative rule, which I think we've defined, and another form would be a policy statement, and another form would just be in the form of an explanatory materials, or maybe it's just limited to the first. But I'm wondering if there's some way that we can just really simplify this to avoid a lot of confusion, because you talk about 6 boxes here. When you're talking about a legislative rule, you're clearly talking about something that's going to be made public. I don't know that it's necessary to have sort of a 6-box framework here. Reeve, do you have any thoughts on this? And maybe the committee has further thoughts, but let's not make. I would strongly recommend, especially for getting this through the council and getting it on the agenda, that this thing does not get unnecessarily complicated, and that we simplify this as much as possible.
Yeah, I'll just second what Matt said. I mean, to have sort of a 3x3 matrix, I think it's going to get exceedingly complicated as to sort of what each of those boxes contains. And, legislative rules will necessarily need to be public. So to the extent that we could, limit it to sort of the 3 big categories, the legislative rules, policy statements, and then other explanatory documents, I think that would be a lot simpler. We can say something as to sort of, whether they're public, but I think sort of trying to put it into a 3x3 matrix, I think is going to be difficult, as far as a drafting exercise is concerned.
I would also think that would find a little bit more favor with some of the agencies who have made the point that, practically speaking, they don't really, when they're drafting these things very often, distinguish between a legislative rule and a policy statement, even because they deem the policy statements to be internally binding and they don't think a whole lot about judicial review and so on.
I guess some concerns I heard were about what happens with things that are in the CFR and will that cause confusion, and then the judicial review point. So I don't know how, if we do this three-prong approach, how we want to just deal with CFR publication and judicial review.
Well, why can't you have a statement that says something to the effect that agencies, often DOT being the example, if what theirs is not a legislative rule but a policy statement, that agencies frequently put these things in the CFR. We encourage them to put it in the CFR, and we don't understand. ACUS at least doesn't understand CFR publication to be dispositive of the legislative rule question per the DC Circuit case law that Jeff has brought up. And further, that if agencies want to reinforce the point that they're not creating a legislative rule, they can include the language that DOT has shared with us on this call from its rule on rulemaking.
I'm curious what folks on the committee, what their view is.
So I agree that simplification is good, but introducing the legislative rule and policy statement language, I'm not sure is simplifying. My instinct would again be to go with like a functional description in terms of, the agencies should just be intentional with respect to the degree to which they intend to be bound by by their statements, either internally or via the judiciary, and they should be intentional with respect to how they plan to publicize their statement, either via the CFR or the Federal Register or other means, and that just a functional description along those lines sidesteps some of the complications that we've been kind of hashing and rehashing over.
But I think that's generally fine. It sort of depends how it comes out on paper here. But are you generally sort of in agreement that those are the basic three categories that we're talking about here?
Well, when you say the categories, do you mean legislative rule, policy statement, and explanatory?
Legislative rule, yeah, a legislative rule, a policy statement, CDOT, and explanatory materials.
Yeah, I think that as we've been, if we could get the right definition of those things and agree to what the definitions are, we could probably agree that those are roughly the categories. Although, there would be this thing about, well, what about a policy statement that's published in the Federal Register? But yes,
well, the recommendation could address that. That's one of the reasons. You can there are a number. I don't think it's the Federal Register so much as the CFR, but you could put. There's no reason that an interpretive rule or a policy statement or a guidance document, in short, there's no reason it can't be put in the CFR. And that should not be under current DC Circuit law, and at least according to ACUS, that should not be the dispositive test of legislative rule status.
Right. I agree. I'm just not sure that that's making things more straightforward to add a bunch of language along the lines that you're talking about.
Well, one of the things, I think, Connor, I think you need to tell us whether whether the committee is basically on the same page, and it's just a matter of coming up with the language. One thing that I would urge is that that we maintain that this recommendation cohere with earlier recommendations where we have been fairly precise about terminology.
Yeah, I'm not completely sure where we've landed. I thought I think we may have to draft it up two different ways and see where folks are. And I know that's painful and more work, but I'm not sure we have a consensus.
Well, the staff's not going to create multiple versions. That's not something that I'm going to ask the staff to do. Reeve, do you want to maybe it's very possible that we do need to see it in writing. I think I've always thought throughout this call that there's different points of emphasis. There's a little different terminology, but everybody, there's a lot of consensus here. In fact, I almost think there's almost unanimity on a lot of these key points. I don't know, Reeve, what do you think? You were making a face.
Yeah, no, I agree. And I guess sort of my question to Mike would be, because it seems like we're sort of more or less saying the same thing. Like, is your objection more to like using the term legislative rule, or is it more to like having the three-part categorization? Because it seems like you'd accomplish the same thing by saying, some rules are enforceable, enforceable in court on judicial review. Some rules are only internally binding; they're not enforceable on judicial review. And then there's this other category of things that's not binding either on the staff or in court. It seemed like we could sort of lay out those three categories without necessarily, using this terminology. Is that sort of what you have in mind, or are you objecting to sort of the idea of?
No, that's right, Reeve. I agree about the categories. I think that, and I don't have strong opinions about some of this language. I think what I'm trying to do is kind of identify a path that doesn't kind of trigger the conversation. But yeah, so I agree that those are the three categories in general of enforceability. There's this kind of separate thing about where it's published and what the publicity looks like. And that's it. And I think that and I agree with Matt that everyone's in basic agreement on the substance, and it's just a matter of kind of figuring out the right language. And so maybe that's just kind of where things.
Yeah, Mike, I think that's very helpful. I don't mean to be wedded to organizing everything around specific terms. I'm just, in terms of conceptually how the committee's thinking about this, I think that's where the committee is, around these basic three categories, and that's probably adequate guidance for the staff in order to go forward. But do you, Connor, Reeve, do you agree with that?
I agree.
Yeah, with the caveat that I still think we have a lot of confusion over terms, and it may be difficult once we look at the drafting to still be on the same page with the terminology.
Matt, this is Jeff.
They're all rules. I mean, one thing that we do know is they're all rules. I mean, we can use rule on rulemakings in a much broader sense than was, don't confine the term to legislative rules, but explain that legally they can take different forms.
Right. So this is Jeff, and I basically agree with what you're saying, Matt. I didn't really like it when Reeve brought in the judicial review part again, because that's the part to me that makes it confusing. So when we talk about bindingness, that I think people will understand. But once we bring in judicial review, the agencies are going to get a little nervous, I think. So, but
Jeff, would you distinguish between bindingness in the sense, I mean, Peter Strauss talked about two senses of bindingness, as did Jillian. One is bindingness in the sense of binding on agency officials. The other is bindingness in the sense of having the force of law, which, I think most people means that's externally enforceable. That is on judicial on judicial review.
I don't think it's necessary to take the next step and just say, why don't we just say that, binding on internally and not binding? I mean,
Jeff, how do you otherwise distinguish between? I mean, it seems like otherwise they're all policy statements. I mean, it seems like otherwise we're losing the concept of something that may in fact be enforceable in a court.
The DOE rule, they said that it's binding.
Binding on whom, though, or binding?
You got to distinguish between the two types of bindingness. That was Peter's essential point, and Jillian's too.
Right, but we're not talking about a regulatory rule here where the agencies are trying to bind the public in any way. We're talking about the agencies binding themselves, and the public might be able to enforce that in court.
Right. So I think this is Don Elliott's distinction, where whether the rule on rulemaking itself will be judicially reviewable. Is that what you're talking about, Jeff?
That's part of it, yeah.
And
but
so
the rule on something could be externally enforceable in court, even if the rule on rulemaking is not challengeable. You could imagine a challenge to the underlying rulemaking where a substantive rulemaking where the validity or some aspect of the rule or the rule on rulemaking, there's a lot of terms here, is not being adhered to, and that's the context in which it would be judicially enforceable. I don't think we're talking about, per Don Elliott, I don't think we're talking about an agency promulgating a rule on rulemaking and having somebody bring a facial challenge to that. I don't think that's what we're talking about here.
This is Steph. I agree with Jeff. I think this discussion of judicial review really invites confusion, especially because, if an agency issues an explainer that has an interpretive role, perhaps that's judicially reviewable. And I would favor the functional approach discussed by Michael Livermore, where the agency, sort of understands the fact that there are different options for articulating what its rules will be with respect to rulemakings and the advantages and the disadvantages of those potential options.
I don't know where we are. Reeve, you're shaking your head. I mean, I just don't know that the staff has adequate guidance here.
I honestly wouldn't know how to draft that. I mean, are we just, unless we're just surrendering the concept of something, and like if we just want to give up on the idea of something potentially being externally enforceable on judicial review and just call it all rules, you know, without making that distinction. But it seems like if we do that, then we're sort of losing a conceptual point that it seemed like everybody agreed was worth addressing, which is sort of there are two different types of binding here. There's binding in a way that can be enforceable against the agency by a litigant on judicial review, and then there's internally binding. And it's the same distinction, by the way, that we've, you know, used in past recommendations, like our guidance documents recommendations, you know, made that very same point, that it can be internally binding without being something that's enforceable in a court against the agency. So if people don't want to make,
take a look at Danny's suggestion in the chat.
Who does?
Danny Fischler, I can read it. Many federal agencies issue statements describing their informal rulemaking processes. Such statements may take any number of forms. They may, for instance, be binding on the agency or not, may be judicially enforceable or not, may be published in the CFR or not. So it's sort of, as I understood Michael Livermore, kind of laying out the considerations.
I mean, I guess that's true as far as it goes, but I mean, I'm just not sure that provides much useful distinction for the agencies. I mean, it seems like if we want to maintain the concept of something that can be externally enforceable, I think we'd have to refer explicitly to that and distinguish that from something that's internally binding. This just strikes me as sort of a statement that's correct as far as it goes, but I think that we're not really laying out those separate categories in a way that I understood the committee to be saying that had some value, that you know, making a distinction. We're not putting our thumb on the scale as to which way to go, but we are sort of laying out that there are these different options. Either you are bound externally or you're not bound externally. You're simply.
And Reeve, it could be, I mean, you know, the recommendation could acknowledge, for Jillian's comment at the first meeting, is you could classify things however you want. You don't really know at the end of the day what a court's going to do with it.
Right. Yeah, you could have an Accardi issue.
Right.
I just don't feel like we have a good summary of the case law. You know, I'm not aware of a lot of litigation related to agency rules on rulemakings and how that has fared in the courts. I mean, I just really think that this judicial reviewability, I don't understand why we would want to focus on it.
So what do we call this? What do we call the instrument when we talk about a rule on rulemaking, Steph? What is the instrument that we're talking about here? What is the nature? What is the agency pronouncement that we're talking about?
I really liked Danny's formulation. I thought it made sense. I think what matters from a statement describing their process, and the statement can take any number of forms. So it could be something you publish in the CFR, it could be something you publish on your website. But I don't know that where it is going to be dispositive with respect to whether or not it's judicially reviewable. In fact, I think it might not be. I think what would be better is for the agencies to be clear about their intention. Do they intend this to be judicially reviewable or judicially enforceable? And some agencies, I think, you know, we had the DOE example, do intend for that to be the case. And, you know, especially if it's like an RFA rulemaking.
Steph, what you asked be taken out, you're just reintroducing right now.
Exactly.
I think what I am trying to avoid is us having categories of types of rulemakings that are not judicially enforceable and letting the agency take a position as to whether or not they.
Okay, so how about this? How about, all right, that's fair, Steph. How about, what about, and I'm just trying to clarify things for purposes of the staff's charge and to keep the committee a little bit on track. I'm not suggesting what the substantive outcome should be here. what happens if, what would the following type approach work? That we define rules on, I don't know if we need to define anything, but a rule on rulemaking is a statement in some respect of how an agency intends, or whatever word you might use, to structure, conduct its rulemaking procedures. That we're not, the committee is not, the recommendation is not going to take a position on how these things should be characterized for purposes of the Administrative Procedure Act and for purposes of judicial review. That in particular, whether they are externally enforceable before the courts, that is legislative rules, or they're just policy statements that are binding internally. And that, apropos of Steph's point, something to the effect of that, as in the case, per the example of the Department of Transportation, that if agencies do not wish or do not intend to be bound by these things in court externally, that they're not supposed to have the force of law, that the agency should so state in the rule, just as DOT has done. And then there could be some further statement about publication that I don't know, I'm sort of thinking on the fly here, that these sort of general rules should be published in the Federal Register / put in the CFR. And in making that recommendation, ACUS is not suggesting in any way that because they're put in the CFR, that is somehow dispositive of the legislative, non-legislative distinction. And it does not in any way dictate its legal status. I don't know, is that get us anywhere?
I think that works, Matt. I think that works well.
We'll take it one more point farther, though, Matt. Some of them only need to be put on the website.
I agree. Like explainers, and I don't know how to deal with. I didn't sort of just contemplate in my head explainers, but I agree with you 100% that there's any number of explanatory type materials that an agency might want to put out that it doesn't want to put in the CFR. And it certainly doesn't, certainly doesn't want to put in the CFR, is not going to put in the Federal Register probably, and just wants to put it on its website.
Could I make this one?
I think we can work that in. Yes.
This is Don. May I make a comment on that proposal?
Please.
I thought, Matt, we agreed previously that the agency's characterizations should get substantial deference from the court. So I would suggest we work that in.
I think that's fine with me. I think that's a great point, Don, and you're a lot smarter than I am. So I think that's a good point. It's up to the committee.
I'm not smarter than you. I'm just making a different point, Matt.
Well, I think, Don, we're on the same page.
Agreed to it.
Yeah, I think we're on the same page, though.
Yeah. Yeah, that's fine.
This is Ryland. So I wrote in the chat, I wanted to comment a while ago, and I have not been recognized. I'm just going to speak up. So I generally like this new formulation that Matt just suggested, as well as what Danny wrote in the chat. And I want to reiterate again what I think Michael was saying earlier, that I really do not think this legislative rule, policy statement, these terms really help us here. I found them very confusing, and I can also say, after our discussion last time, I took this back to my managers at EPA, and I think folks generally found that kind of confusing. So I would be in favor of a more functional approach, which I think is what we have in this shared screen document right now.
And I think this basically comports with what everybody's view on this is. And I don't know, that's my sense.
I agree with you, Matt.
And let's not forget, the title of this project is Rules on Rulemaking. And a policy statement is a rule. And I think DOT has made that point very well on the call, that you could have something that's very rule-like, but it may well have a disclaimer about judicial review and so forth and so on. And that's still consistent with the objective, I think, of the project.
Yeah, Matt, if I could just respond very.
All right, there's too many people who want to talk, so you guys go ahead.
I just want to respond very briefly to Matt's last point. I think it's true that under the APA, policy statements are rules, but I've read at least one DC Circuit case that says, policy statements and interpretive rules are substantive rules, and that procedural rules are a separate category. And I think that's borne out by the text of the APA. And I think, to the extent the agency wants to promulgate a non-binding procedural rule that's in the CFR, that I don't think policy statement is necessarily the right term for that. And again, I think this is another reason to move away from these terms.
Yeah, I think that we can. I think we can move away from the terms. The terminology. It's incredible that everybody's so confounded by this terminology 75 years after the APA was enacted. It sounds like the terminology is problematic. I suppose then when the staff takes a hand at drafting this, we can make some references to. We could make some references maybe in footnotes to prior ACUS usage, just so this coheres with earlier recommendations. But I don't think it needs to define the recommendation, and they shouldn't be sort of foundational concepts for purposes of this recommendation.
So I agree. We're definitely off the idea that for the purposes of this recommendation, rules on rulemakings refers only to legislative rules.
Precisely.
Okay.
But we're not foreclosing the possibility either. I mean,
Right. But I'm not sure.
I don't think anyone wanted to.
Yeah, I'm not sure how many agencies are going to want to actually do that. I mean, notwithstanding the fact that DOE did it, I mean, and Paul suggested that some agencies might want to do it. I'd be a little surprised that agencies would want to consciously make them just externally enforceable by private litigants.
No,
I don't think we need to foreclose it, though.
Yeah, we don't need to foreclose it, and it would not be something that anything would highlight it. And probably the main thing the recommendation would say on that front, Jeff, is the agency would state its intention, just as DOT has done in its rule.
Okay.
I was trying to make the point that I think the title "Rule on Rulemakings" is still apt, because if you take something, these documents are all going to be rules in some form or another. That's the reality.
I think it is still apt now that we've changed the framework.
Does anybody have concerns with this framework in our last few minutes here?
Hi, this is Danny. I do have a concern with the second sentence of this draft, and I recognize that we're doing this on the fly and it's a little rough, right? So I'm glad to reserve the specifics to maybe line edits on what comes out of the staff's work. But I am concerned that explicitly stating that we don't take a position as to judicial reviews suggests that we think that there is a view of the APA that doesn't allow agencies to put something in the CFR that is unenforceable. So I'm a little concerned that there's an implication here that there's some sort of controversy over that point, where I'm not sure there is. My second concern on
Danny,
this
can I address that one?
Yes, please.
Can I just address that one? I think the point you make is exactly right, and that we probably should state in the recommendation that we're not by any means taking the position that agencies can't put something in the CFR without finding themselves externally bound in a courtroom.
That would be very helpful, actually. Thank you.
ACUS used to put its recommendations in the CFR.
Exactly. Sean knows about that. It costs money, though.
Unfortunately, they still weren't binding.
Except on Egypt.
And my second concern And I think it's just it'll probably come out in the editing, relates to the statement that an agency's characterization is given great deference in court. I think as that relates to the characterization of something as a legislative rule or a procedural rule, I'm not sure that's accurate as a matter of law. And I'm not sure that the plenary would necessarily agree to it. That could become the reference to deference. Sorry for the rhyme. Could become sort of a flashpoint in the plenary, and something like that could be stricken. So if we could choose a better term than deference to get at what the committee is trying to say, it might give me a little more comfort.
I think it would give all of us a lot more comfort we can make Don Elliott's point without using the word deference. I don't know what word is best, but you're absolutely right. That's like that'll be like a flashpoint at the plenary session, the word deference.
I wanted to follow up quickly on that point, and I wonder if we should make more clear, like what is the agency characterizing? Are we talking about, for a rule that is in the CFR, the agency's characterization of whether that's judicially enforceable or not, that gets deference, or whether something is a legislative rule or policy statement, or whether that gets deference? There's obviously a lot of case law on that latter question, and I think maybe if we stick with that former question of just our characterization of whether the rule is enforceable or not, that might just help narrow the scope of this a little bit.
And I think that's what the intention here is. I mean, if maybe a footnote refers to legislative rules and policy statements, but I think that's the basic intention. Isn't that right, Reeve?
That's my understanding. Yes.
I think this is something we could work on drafting if we have general buy-in with this general approach. I think we can draft, but I think we're over time. I don't think we can do a lot more drafting at 5:01 after a long meeting.
Well, Connor, thank you very much, and thank you everybody for hanging in there. I'm just the reason I try to clarify these things is because otherwise, come Sunday night, at 11 o'clock, Reeve, Todd, and I will be yelling at each other on the phone about what this should say, and I don't really want to be in that position. And that doesn't serve the committee very well either, because at the end of the day, it's the committee's recommendation, not ours.
You're the chairman.
Matt, thank you for your thoughts, for putting this forward. All right, so we will have a third meeting. Todd will circulate the information. Thank you, everybody, for so much and for hanging in there for 3 hours. If you have specifics, send it to Todd, Reeve, and me. And have a good night. Thank you.
Thanks.
Bye, everyone.